Yes, ma'am.
Yeah, I know, right?
Can you give me a number? I mean, that's that.
It's like, oh God, so nobody knew they had one. You're three things, enjoy that, sir. Yeah. But RDA.
So just, okay. Okay.
I finished doing all my housekeeping up here. Who's got something that's ready?
Mine's ready.
Okay.
Self company.
That's fine.
Oh. Done right.
Okay. All right, everybody, let's come back to order. We're gonna do two quick pleas, maybe some other little bit of housekeeping, and then we'll move to the conferences. So, all right, so let's do this. Sir, I'm gonna place you under oath. Are you ready?
Yes, sir.
Do you solemnly swear or affirm that the testimony you're gonna give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, state your full name for me.
Timothy Jerry Crumbly.
Mr. Crumley, you're here on 23 SR 0345. And you're here today because your sentence enforcement supervisor has filed paperwork alleging that you're out of compliance with your probation. Do you understand that's what you're here to do today?
I do.
All right. It is my understanding from the announcement that you're on first offender probation, and that what we're going to do is, with the consent of your attorney, revoke the first offender, and I guess some sort of straight time to serve. Is that right? Okay, straight time to serve. Is that what you're expecting right now?
Yes, sir.
All right, is that correct, Mr. Charles?
Yes, sir.
All right, I'm actually going to swear you in on everything real quick. So if you'll raise your right hand. Ms. Oliver, do you solemnly swear or affirm that the testimony you'll give in all matters today across all hearings will be the truth, the whole truth, nothing but the truth, so help you God? All right. Okay, so let's see. Do you all have his, other than the order removing him, do y'all have his paperwork handy by any chance?
I have a copy when he pled guilty.
Okay,
That was on May 12, 2025.
okay. Well, what I can do is, you could do this, we could do this on a blank order. Or do you have a order there attached to yeah, we can do it off of that. Perfect. All right. All right, Mr. Crumbly, do you agree that that there's enough evidence here if we'd had a hearing for me to decide that you have violated your probation to the point where I would remove you from the first offender?
Yes, I do.
All right, is that correct, Mr. Charles?
Yes, sir.
All right, and do I have your consent, Mr. Charles, to remove and revoke his first offender status and sentence him to, I believe the recommendation is 120 days to serve?
Actually, it's 100 days to serve.
100 days to serve.
Yes.
And terminate the balance?
Yes, sir.
Okay. Mr. Crumbly, do you understand that that is the recommendation?
Yes, sir.
All right, so the way this works is you've already entered the plea, so we don't have to go all the way back through that. All we have to do is have this conversation, put this on the record, and then I will fill out this form here, doing exactly that. So do you have any questions for me, Mr. Crumbly, about anything?
No, I don't.
Okay, then I am going to mark here on the order regarding probation revocation. I'm going to read this out and then I'll ask Mr. Charles if he wants to do anything else, which is that the defendant has stipulated to the violations, which just to read it out loud, the violations are testing positive for methamphetamine on July 24th, 2025. Mr. Charles, do y'all stipulate to that violation?
Yes, I do, Your Honor.
Is that correct, Mr. Crumbly?
Yes.
All right, and then the sentence is to serve 100 days in jail, credit for time served. He's not going to go back to probation. First offender is revoked, which means that from this moment forward, Mr. Crumbly, this sentence in 23 SR 0345 will appear on your sentence as a conviction. Do you understand that?
I do.
All right, Mr. Charles, anything else?
No, sir.
Ms. Oliver, anything y'all need that I've missed?
Yes, sir.
All right. Take a look at that. Once you sign it. Mr. Crumbly and Mr. Jackson. Mr. Crumbly, take a look at that document with your attorney. Once you've signed it, that'll conclude this hearing.
Y'all ready? Stand right there.
All right, everything looks good. So I'm going to pass this to the bailiffs. They're going to make copies of it. And Mr. Crumbly, do you have any questions for me before we close this out?
No, I don't.
All right, thank you so much. Anything else, Mr. Charles?
No, sir. Thank you.
Mr. Crumbly, if you'll return to the jury box, please.
Your Honor, you'll just take this.
Yes. All right, this is Stephanie Payne.
She was in the chair.
This is the one you emailed me about, right? Say- This is great. This is a great solution. I'm all in. In fact,
Thank you, Your Honor.
I'm already initialing all of my parts on it, so this should go fine.
Okay,
All right, you ready?
we are.
You ready, ma'am?
Yes, sir.
You ready, Terry? Okay, thumbs up. All right, ma'am, please state your full name for me.
Stephanie J. Payne.
Ms. Payne, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Ms. Payne, you were here on 23 SR 0469. You were on time for court today, and you're here with your attorney, Ms. Gomez. Is that all correct?
Yes, sir.
Your attorney has passed up to me this attorney and defendant plea rights waiver. Do you recognize this document I'm holding up?
Yes, sir.
Are these your initials next to each of the lines on page 1,
Yes, sir.
page 2?
Yes, sir.
Is that your signature?
Yes, sir.
Did you sign and initial this document after having all the time that you needed to review it?
Yes, sir.
And I'm sorry, to review it with your attorney?
Yes, sir.
And did you understand everything that's on it?
Yes, sir.
Ms. Payne, have you had all the time that you need? Do you have any questions for me about anything anywhere on this document?
No, sir.
Have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, sir.
Are you satisfied with the job Ms. Gomez has done on your behalf?
Yes, sir.
Do you understand that you have the right to a jury trial?
Yes, sir.
And that by entering this plea, there will be no trial, this case will be closed? Is that what you want to do?
Yes, sir.
All right, any questions for me about anything so far?
No, sir.
Ms. Gomez, do you stipulate there's a factual basis in 23 SR 0469 to support this one count of disorderly house from 12/23/21 here in Spalding County?
I do, Your Honor.
And ma'am, do you want to enter a guilty plea to that disorderly house charge?
Yes, sir.
All right, I find with the attorney's stipulation of the factual basis combined with the defendant's request to enter a guilty plea, there's enough for me to take this plea. I find that Ms. Payne is knowingly, voluntarily, and intelligently waiving her rights and entering this plea. I reviewed the recommendation and I'll follow it. Floor is yours if you want to add anything.
Your Honor, I'd just like to thank the court and Ms. Sexton for helping us work this out for Ms. Payne.
Yes, and they've been communicating with me all along, so I was looking for this case this morning, and I appreciate that very much. So, okay, anything else for our sentence?
No, sir.
Ready?
Yes, sir.
Here we go. Ms. Payne, the sentence of the court is as follows. On 23 SR 469, count 1, disorderly house, guilty. It's 2 days to serve. You've actually served significantly more than that.
Yes, sir.
But we're just going to do 2 days and call it quits. It's credit for time served in full. You will not be going back to jail. There's no probation conditions. And this closes your matter out altogether.
Thank you, sir.
You've already signed the paperwork, so I'm just going to date it here. You have 30 days from today if you wish to appeal this decision. You have 12 months from today if you want to use your habeas rights. Anything else, Ms. Gomez, as we wrap this up?
No, sir. Thank you very much.
Any questions, Ms. Payne, as we wrap this up?
No, sir.
All right, the bailiffs, if you two will just wait by the door back there, and Ms. Gomez, if you'll come up here just real quick.
Sure.
And the bailiffs bring your paperwork in.
Thank you.
Okay, any other matters from private attorneys that I can address before I go to the rest of the conference?
Your Honor, we've got this, just,
Is this on Fox?
yes, Your Honor.
You get that, Terry? It's in Fox 23 SR 400. It's
And why would we do the acceptable? If there's been more progress, since we want to make sure that anything in the system. Is that all
Actually, this one is give you guys more information if the folks give me difficult.
Yeah. It's looking very different lights around.
Okay. This one actually puts a pretty good piece of that. Right, you'll get Carly's. Ian Cox, it's IAN, COX, 23 SR 400, and it's a bench one. They had a mission for a bench one.
Okay, thank you.
Great. Okay, do you have anything else that's ready?
No, Your Honor, just say.
I'm just waiting. So, all right, so now we're going to move into conferences. So let me just say one more time in case y'all forgot. The sentence enforcement team, Ms. Peterson and Ms. Oliver, one of them will speak with you. Again, they're going to give you the state's offer. If you want to accept that offer, sign it and be free to go, then you sign it. If you do anything else, you have a hearing with me and I will make the decision on that case if that is what you want me to do. Those of you that need to have conferences with Ms. Sexton, she will call you up at the appropriate time. And that's it. So I'm not going to come back at a time certain. I will come back when the bailiffs come get me and tell me that we're ready. If you need to step to the restroom, that's fine. I also know, Mr. Stringer, I believe you said you have something available for the state to see or get a copy of or something. So we'll let you talk to Ms. Sexton during the break. Give her a copy of whatever it is you brought with you, and then we'll sort that out. Okay? All right, that's it. All right, if y'all need anything, let me know. And with that said, we're in recess.
All right.
What I'd like to do first is call the calendar again. Let y'all tell me what we did, what we didn't do. And then I will hand the calendar over to you, Miss Oliver, to call the rest of the way out. Everybody ready? Okay. First case was Anderson, and that is a warrant. Second case was Ba. That's a consent. Excellent. All right, everybody can mark Ba off your calendar. Cawthorn. What did we do with? That's a hearing? Okay. All right. Cleveland is off. Oh, Brewer.
Doesn't leave popcorn, there was no consent on.
Nothing offered? Okay. No consent offered. Okay. All right, anybody need anything else on page one? We had the walk-in with Dutton, Ian Cox, 23 SR 400. We dealt with that. We're done. All right, moving on to page two. Crumbly was a consent, first offender revoke. We did the plea or did the consent hearing and we're done. Ellis is a probation modification. We'll circle back to that. Garvin was sick.
Reset.
So I reset her. I think we may have, you were out last week because you went on vacation because you should do that. But at the end of last week's calendar, I canceled the 3rd, which is information I didn't get to you. So I think we set her for the 3rd. Is that right? We might need to.
It was for June.
June 4th. For June. Okay. Then we're good to go there. All right.
June 4th, Judge, you canceled.
So it's whichever one.
Yes, June 4th is canceled. June 4th is canceled by Judge Thacker, and then July 3rd, I believe it is, was canceled at my request.
So again, we've moved more court in 2026 than I've moved in my entire career. So the fact that this is confusing is just a moment where I just need everybody to say, let's stop and talk it through. And so I'm sorry is what I want you to hear me say. If that has caused these to be missed, I'm sorry, and just let me know what I can do to help fix it.
June 4th and July 2nd.
Yeah, in fact, James and Angel are actually at this exact moment sitting in my office, going through the calendar themselves to get the bailiffs on the same page. So it's, again, this will settle down, but y'all don't need me to tell you this is a difficult transition. So, okay, Garvin was reset because she was sick and I didn't want her here being sick and getting everybody else sick. Hardy was actually, it came in as an ignition interlock device, but it's actually a request for a modification. Ms. Sexton, did you happen to get a chance to talk to him over the break? You didn't, it was not originally on your list, and I don't know that I communicated with you.
So it wasn't originally, but I have to talk to him,
Okay,
and he's gonna have to talk to you on our, I'm going on the record as saying the state will consent to anything that you do on this, but I think you're gonna be between a rock and a hard place.
okay, that's fine. We'll circle back to it. So, all right, Maren,
I spoke with Mr. Dutton about that. That's like, that's a status. We're gonna try to work something out. That's not even on a calendar. We're just trying, he just brought it to
okay,
work something out.
all right, so you don't need anything from me on
I
that.
don't need anything from you. I'm
Okay.
waiting on some stuff from Mr. Dutton.
Okay, all right, McGee was a consent with Van Mater. David McLeod, consent, okay. All right, Nally is going to be a null pros. If I haven't already signed that, I certainly will.
We have to do it, Your Honor.
It's all right. Again, I just wasn't sure if I'd signed it or not. All right, Overby was a warrant. Payne was a plea. It's done. Ponder is off. Prather, this was part 2 of a 2-part hearing. She brought me all the paperwork I needed. She qualified for the restriction, and we did a restricted null pros over the break. And that way there's a record of it, that's what we did, and we signed it, and that case is gone. She's gone, and that case is good. All right, Singletary is a warrant. Mr. Stringer is here on the court's motion for contempt, or hearing of contempt. Weems is off. Brian Williams. Consent. Okay.
Your Honor, I believe Mr. Hardy will be a relatively quick,
Okay.
and I have some paperwork for you to see.
All right, Mr. Hardy, come on up, and then I'll give the calendar over to you if you're okay with that.
Mr. Hardy brought this in. This is good paperwork, so we can try to.
All right. Good morning, Mr. Hardy.
Good morning.
All right. If you will please raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right. Tell me your full name.
Robert Leandre Hardy.
All right, Mr. Hardy, you were here on 24 TK 2962. There we go. And I initially had you as hunting an ignition interlock device from me, but it looks like you actually are looking to have your charges, your conviction modified. Is that correct?
Correct.
What is it you need from me to fix whatever the issue is that you're having?
So essentially, when I was here and I pleaded back in 2024, I asked the court, would this have an impact on my driving record? I was told no. Come now, I'm essentially being denied insurance because of this one charge. I've tried to go to the DMV. I've tried to go different insurance companies. They're telling me that this one ticket on my record is preventing me from being able to drive. Well, being able to renew or find new insurance. So I suppose I'm requesting the court to either reopen, to find some way to make this ticket not appear on my driving record, to vacate or modify the charges. Modify the speed listed.
You're being denied insurance altogether?
At least from Farmers, State Farm, Allstate, and Progressive.
Do you have other?
No, I have no tickets, no, that's in my driving report. I have no suspensions.
All right. I'm going to try to repeat back what you just said to me. And I
Mhm.
want you to disagree with me if I'm hearing it wrong. This is
Mhm.
really important, okay? So I'm not stating a fact. I'm doing this back to you as a question.
Mhm.
Am I correct in hearing that you've had no other citations in the last 7 years?
Correct.
And you're telling me that you had this one citation of 75 and a 55 for 20 miles over the speed limit.
Correct.
And you entered a NOLO
Correct.
with no points.
Correct.
And that has caused you to lose all insurance opportunities with Farmers and
I
State
tried
Farm?
Farmers, I tried State Farm, I tried Allstate and Progressive. I currently have Progressive. When I tried to go and renew, I was denied. That's what made me seek other insurance. And that's when finally State Farm gave me a LexisNexis report that said that that was essentially why I was being denied.
That's not even, it's a fast speed, but that's certainly not like I would pay attention to it fast speed. Like there would be no scenario where I would even pause in a plea to say 20 miles over. That's very standard. How old are you?
24 years old.
How old?
This happened in 2024, so I was 22 at the time.
Yeah. You were 21 and over. So this is definitely going to be one of those moments where I'm going to say this and then I'll never be able to say it again. But I mean, I've been doing this in one form or fashion for 2.5 decades now. So, so I've either sat at the prosecution table or I've sat at the defense table or I've sat at this table. And this is the first time I've ever heard of a single citation for speeding with a no-low plea for 0 points, which I am reading off of your driver's history. I need to say that out loud. We're not making this up. I'm reading this off your driver's history, causing someone to absolutely be denied insurance moving forward. I don't understand that at all.
Your Honor, most of my life is in Atlanta. I go to school at Georgia State. I work in Atlanta, so this would significantly impact my future, not being able to legally drive.
Okay. Wow. I'm also looking at you in my database. And my database includes my court, Superior Court, and Magistrate Court. And it's just this one ticket, and that's it. Interestingly enough, I mean, you're only 6 miles away from a 0-point offense that wouldn't go in your driver's history at all. So I'm just baffled. Okay. Let's do this. I need to do a little bit of homework, and I need you to bring in whatever it is that's caused, whatever it is from the insurance companies that's telling you you can't have insurance. Because I don't, what you're saying to me and my understanding of this world do not match. I'm not saying you're wrong. I'm just saying there's something I'm missing.
I can get the LexisNexis report.
Yeah, I would like
That's
that
the
very
one
much.
that-
I'm going to reset you. Margaret, may I have copies of these?
Is there a way I can request virtual, Your Honor? Because
Do
I'm
what?
having, is there a way I can request a virtual hearing? Because I
Yeah,
have
come
to
back
miss
virtual. That's fine.
work and
So yeah, if you just put on there virtual approved. So yeah, that's perfectly fine because I have what I need here. I also, so if you're going to come back virtually, grab our cards and I'm going to have you email to Miss Sexton and myself. That's Alexander's card. Those are my cards.
I believe only one insurer provided a LexisNexis report. I can try to reach out to the others to get whatever sort of, I just have emails
Okay.
of the denial.
I tell you what, I'm going to, this is my staff attorney's card. I had a card up here, but apparently somebody really liked my cards and took them. Okay, John, if you'll give him that. So that card has my staff attorney's email address and I just wrote mine on there and get Miss Sexton's card as well, or go by the solicitor's office on your way out and get it. And then email us that Lexis report.
Okay.
And of course, next time you'll be able to report virtually.
June 11th is technically the next one in this full, and then the next one would be in July 16th. So
Go ahead and do the June 11th because I actually don't think we're going to have a hearing. I think as soon as I can see that, I'll be able to make a decision. So I may be able to make a decision before we get back to the next court date.
Okay.
So the quicker you get that to us, the better.
I should be able to have it today.
That's fine. And again, I'm going to keep copies of this. I'm just really surprised that this is the outcome. And I want to know what I'm missing because if there's you, there may be others. And if there's others, then I want to make certain that what we're telling folks will happen is accurate. And if there's more information we need before we do pleas like this, we need to know. So you should know I'm looking at both you and I'm looking at how we handle this type of case. Do you see that?
Thank you.
Okay, you're very welcome. All right, so that's it. If we have to have the next hearing, we'll do it virtually. But again, I think once you get that to us, I will have the information I need to go ahead and make a decision on this.
Okay, thank you.
All right, thank you so much. You're free to go, but sign, I'm so sorry, not free to go. The bailiffs are gonna have you sign your reset. Once you've signed your reset, then you'll be free to go.
Okay, thank you. Your
Thank
Honor.
you so much.
I'm gonna write it right here. Right here. I mean, I do, but I didn't bring it. There you go.
All right, everybody can close up Mr. Hardy's case on your calendar until whatever date it was that Carly chose. You said June 11th? Reset to June 11th. All right, any other housekeeping before we jump into the next cases? Okay, then what we're gonna do next is, I'm gonna let Miss Oliver call the probation matters in whatever order she sees fit. So, you ready? All right. And if you'll flip your mic on and pull it up. Otherwise, yeah, Terry's giving me a thumbs up. See, I do write stuff every now and then. Is this your only, this is the only probation revocation?
Yeah, Ellis is here for modification.
Okay.
But as far as revocation, this is.
Okay, perfect. All right, if you will please state your full name for me.
Valerie and Lynn Cawthon.
Ms. Calden, if you'll please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. Ms. Cawthon, you are here today on 23 SR 1406 because your sentence enforcement supervisor has filed paperwork with me alleging that you are out of compliance with your probation. Do you understand what you're doing here today?
Yes, Your Honor.
All right. You are. There's two things that are about to happen. Do y'all have a recommendation that you want to put on the record or no recommendation at all? I don't have a preference.
Probation asking for 30 days in jail. 30 days in jail.
Okay, so what Ms. Oliver is going to do is she's going to read out the allegation that's on the table and then what the recommendation is from the state.
Okay.
And then I'm going to ask you two questions. Do you admit or deny the allegations? And then is the recommendation acceptable or not? Do you accept or reject? So do you admit or deny the allegation, and do you accept or reject the allegations? I mean, accept or reject the recommendation. Do you understand that?
Yes, I do
Okay.
have a question though. Is there a possibility that I can request to speak to you guys towards the end? Because I do have a handful of things I would like to explain
Yes, I'll give
as
you all that.
far as the whole situation.
Yes, you will have an opportunity to address, you will have a free moment where I will say, what is it you want me to know? Okay?
Okay.
But I will go through that in a little more detail when we get to it.
Okay.
All right. All right, go ahead.
Judge, on docket 23 SR 1406, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant has failed to provide progress of obtaining a GED as ordered. Probation is asking for 30 days in jail. Just for context, she was originally a pretrial. Her pretrial was revoked on July 31st, 2025, and she was placed on probation and currently has 63 days remaining.
Okay, thank you. All right, Ms. Cawthon, do you admit or deny the allegations?
Admit.
Admit, okay. And do you accept or reject the recommendation that's on the table?
As far as the 30 days in jail, reject.
Reject, okay. And how much time is left?
63 days.
All right, so I have 63 days to work with. Okay, Miss Oliver, ma'am, you have a seat right there in that first seat. This is officially
Yes, ma'am.
a full-scale hearing because I'm going to need to make my own independent decision as to what to do with this case. So although you have admitted, I do need a little bit more information from the state. So what's going to happen is Ms. Oliver is going to provide me with some testimony. Ms. Sexton may ask some questions as well. And then you'll be given the opportunity to ask some questions of Ms. Oliver if you think she has information that would be helpful. Do you understand that?
Yes.
And again, although we're talking about the facts, what I'm really doing is trying to figure out how we got here
Mhm.
and what should the court's response be to
Okay.
this violation. Okay? All right, Ms. Oliver, the floor is yours, and then Ms. Sexton will follow up if she has any questions. And if you'll just fill me in like from the beginning. So we started out as you said a pretrial.
Yes, it started out as a pretrial. She was sentenced on 9/26/2024 for 12 months on the pretrial diversion program. Her only violation on that case was obtaining her GED. That pretrial was revoked on July 31st, 2025. She was removed from the pretrial and placed on regular probation.
So you've given me June 26th of 24, pretrial started. July 25th, 2025, pretrial ended.
No, pretrial
revoked.
started September 26, 2024.
Okay.
It was revoked on July 31st, 2025.
Okay, got it. All right, what happened next?
Her current case, active on probation as of 7/31/2025. She had no court fine. Supervision fees were waived, intake fee was waived. She needed to show proof of high school graduation completion or obtain GED by April 30th, 2026.
Okay, you're telling me were there any other obligations other than GED?
The only other obligation was no violent contact with Regina Henderson. Or Hernandez, excuse me.
Any prior revocations other than what you've named so far?
Not on this case, no, sir.
Okay. And I have how much time left?
63 days.
Okay. All right, anything else?
No, sir.
All right, Ms. Sexton, any questions?
This is my only question, and I'm gonna apologize to the court because I don't have my paperwork here. I think I remember dealing with this case on a pretrial basis that Patrick had, where there was a recommendation for the GED. And then that recommendation, did it continue over into her probation? And it was the state's desire that the defendant, who's very young and I believe has a child. Do you have a child?
I do.
And has a child?
This incident happened when I was 17 years
Oh,
old.
can't hear.
That-
Hold on. Ma'am, you just wait. Ms. Sexton was clarifying. Go ahead.
So I was just asking for the clarification because it's not normal that we request a GED. But so my question to the defendant is,
We're actually,
oh, I'm sorry. I'm
let's say
sorry.
you're just ahead of the process. That's
I'm
all.
so- My apologies. I got lost. Can you tell me what movements towards the GED completion were made after the pretrial was revoked?
It doesn't look like there was any movement. There has been no updates. There's been nothing as far as obtaining that GED.
And how long has the defendant been in the probation program?
Since
Not counting the pretrial, because that.
not counting the pretrial, she's been on regular probation since July 31st, 2025.
And there's been no documentation regarding movement on the GED.
No, ma'am.
Okay. That's,
All right. Ms. Coffin, it's Coffin, right?
Yes.
Ms. Coffin, you may ask Ms. Oliver any questions that you think might be helpful to your defense. This is not the time to make any statements. This is just the time to ask questions. We'll get to the statements in just a minute.
I don't really have any questions. I just have information and statements I would like to share
That's
with
fine.
you
I just want
guys
to make
whenever I
certain that
get
you
that
had the
chance.
opportunity to ask questions if you wish. So, all right, I'm going to find that she's declined to ask questions. Anything else, Ms. Sexton of Ms. Oliver?
No, sir.
All right, anything else?
No.
All right, then hers is closed. Do y'all, any other witnesses for the state?
Yes.
Okay, all right, so Ms. Coffin, the state's rested, which means that they've given me what they're gonna give me for me to make a decision on this case. You have the opportunity at this moment, but not an obligation. If you wish to testify, you're already under oath, and you'll be given the opportunity, you can testify if you wish. Ms. Sexton may ask you questions, and you'll have to answer those questions.
Okay.
Do you understand that?
Yes, Your Honor.
You have the absolute right to remain silent, and if you choose to remain silent, that silence cannot be held against you. Do you understand that?
Yes, Your Honor.
All right. Hey, John. Okay. Ms. Coffin, can I answer any questions for you about your options at this moment?
Will I find out the options that I have towards the end on what your decision will be? Or I'm confused on what's going on.
So what's happening right now is you're a criminal defendant
Okay.
and we're in this hearing, and what's happening is we're at the stage now where you have the right to testify and you have the right to remain silent. Are you with me on that?
Yes.
And do you understand that if you choose to testify, you can do so, but you'll be also forced to answer any questions Ms. Sexton may ask you.
Okay.
But if you choose to remain silent, that won't be held against you, and you can't be forced to testify.
Yes, Your Honor.
Are you with me on those steps so far?
Yes.
Does that address the questions that you've asked so far, or do you have additional questions on framing up your decision? Because the next decision you're going to make is whether you want to testify or remain silent.
Yes, Your Honor.
So do you want to ask me anything else about whether you want to testify or remain silent?
No, Your Honor.
Do you want to testify
Yes.
or do you want to remain silent?
Testify.
Okay, so I'm going to leave you at your seat. Y'all stay put. You're going to use that microphone. Do you need to move a microphone over to her? Don't you have that secondary mic you move around? What? Okay, so she uses that mic. Is that good enough? Okay, that's fine. So if Terry waves at us, we all stop talking and get regrouped because Terry is making the record of the court, and that record is not here for me. It's here to protect you. And so if she waves at us, we will stop and we will regroup. Okay? All right. Over you. I just want to make certain you're happy. So, okay. All right. So you may testify, Ms. Coffin, and tell me what you want me to know. I'll ask you a couple of clarifying questions to make certain that I understand what you want me to know. And then Ms. Sexton will ask you questions.
Okay.
All right. So nice and slow. Tell me what it is you want me to know about this GED issue.
I don't have it printed out. I might have it printed out, but I did actually make progress on my GED. I was only able to get one test done. I did fail, but I have done multiple practice tests, like, going on, writing on paper, going back, answering them. Out of like 8 that I have done, I've only passed 1. I also have not had a job since December due to an injury that I had. So I have also not had any money to try to pay for any test as well. I have a lot of health issues that's been going on that I found out about the end of August. As far as gallstones and a lot of inner bleeding and things like that I'm dealing with. I also found out that I was diagnosed when I was younger, which I do have proof on my phone. I was diagnosed with autism. It's just kind of difficult as far as I'm not exactly the quickest learner. And with me being a slower learner and a slower pace as far as learning, I was in special classes in school and stuff as well. It's definitely just taking longer to obtain the GED because of me being a slower learner. I am moving into Tennessee on June 16th. And I do have my mom that is helping me get into in-person classes when I get up there because obviously online classes are not helping me. So I am going to be into in-person classes. The situation happened. The reason I'm on probation, the situation happened when I was 17. I have been good. I have done everything you guys asked me to do, except for the GED. I've paid my payments when I had them. I did every report. I've done everything that I could possibly do. It's just, I've tried my GED. I've just failed. I haven't been non-compliant. I haven't been disobeying and not doing it. I have been trying.
Okay. So what I'm,
I also, not to mention, I'm trying to be a mom for my child, but my stepmother has my child because I cannot take care of him right now on my own. So
okay,
I'm also trying to be a mom, which is also struggling as well.
all right. So what I'm hearing you say is through the pretrial diversion program and and then the subsequent sentence from the plea, you completed everything but this one GED test.
Yes,
But
I've-
GED completion.
Yes, the only thing I have not done was a GD completion. And I have attempted. I've done every report, I've done every payment. When I had them, I've answered every email that I have gotten with you guys and done everything. I've never gotten in trouble with police. I've never gotten in trouble with the law, anything since the incident that happened when I was 17, which is the reason that I'm on probation today.
And that you've been unemployed since December of 2025.
Due to an injury, which I do have paperwork for if you want to see. It's a whole stack of doctor papers from the visits because I've been out of work.
All right. And
So-
that you had health issues since August of 2025.
Found out about them, yes. I've been going hospitals off and on due to pain and come to find out it's interintestinal bleeding plus gallstones. Plus I have to get my gallbladder taken out, which I also can't afford because I don't have insurance. So I'm struggling with my health problems myself that I can't even afford.
All right.
So-
And you said you were recently diagnosed as being on the autism spectrum,
Yes, Asperger's specifically.
Asperger's. Okay. And then I heard you say somewhere in here that you're moving away.
Yes, I'm going to Tennessee because the family's moving up there with the rest of the family. So I am moving up there on June 17th specific date.
June 17th, according to my calendar.
And if I'm not mistaken, whenever I sent the email that I needed, that I wasn't going to be able to complete my GED in time, I did also address that I was moving to Tennessee, and that's why I wanted to speak with you.
All right. Anything else, ma'am?
No, I think that'll be it.
All right. Miss Sexton may have questions for you.
I don't have any further questions.
Okay. All right. Ma'am, anything else you want me to know before I make my decision?
No, Your Honor.
Okay. All right. The evidence, as I have heard it, is that Ms. Cawthon went on our pretrial diversion program, which I'm looking at the documentation here. As we've been hearing this for simple battery and family violence. So her charges were serious. They're family violence charges. They are high and aggravated misdemeanors, which means that if I do revoke any jail time, she's only entitled to 4 days of credit per 30 days of sentence. I do note that this plea was virtual. I don't know anything more about that. No violent contact. And other than that, other than the no violent contact, she had some fines to pay or fees to pay. And then it was just obtain her GED. So there were not a lot of obligations on this original sentence. And so we moved from there through, we removed her from the program on July 25th of 2025. She ended up entering a plea to the charge. And then went on probation. We now have 63 days left of that sentence. Ms. Cawthon, part of the problem here is that had we known at the time that this was not going to be successful, this would have been a very different sentence. But you told us you could do this.
And I have tried to do it.
I've gave you your hearing. And I realize that I did not ask you to remain silent while I was doing this, but I am now. Because I gave you your opportunity to tell me everything you wanted to tell me, and I circled back with you a couple of times to make certain that you gave me everything you wanted to give me. And then this is the part where I talk. So I'm going to open it back up to you now to tell me what you want to tell me. And then you're going to stop talking for good, and then I'm going to talk, okay? All right, go ahead and finish what you wanted to say, and I'll hear it, and then I'm going to do my part. Go ahead.
I also did forget to mention the first part when I got first put on probation, I was pregnant also, so that also didn't really help with the fact of that first part of my probation, the reason that I didn't get to complete it the first half.
Okay.
Your Honor, can I ask for clarification? Are you
Sure.
talking about that she was pregnant? Are you saying you were pregnant during the pre-trial or during the probation?
When I first got put on probation, I was pregnant.
So how many children do you currently have?
1. I was pregnant in 2024, which was when I first got put on probation.
That was the pre-trial, Your Honor, I believe?
The pretrial I show, according to my dates, was from June of 2024 through September of 2025.
So I'm just trying to get clarification because I believe the GED and a pretrial, which is never offered on a family violence, was offered because she was young and pregnant. But I'm
Yes.
just trying to get my dates right because I know that I did the probation, but I did not do the pretrial plea. I believe Patrick did that.
Oh, I said that wrong. The pretrial was entered on, I said June 26th. I meant to say September 26th. So the pretrial started September 26th of 2024. So I'm just saying that I said that wrong a second ago. I'm correcting the record on that. Okay. Do you want to ask her any other questions?
So again, I'm sorry, I am very confused. You say at the time you were put on probation. Now probation is different from pretrial. Do you understand the difference? Okay, that's where I think we were. When you presented and you were offered a pretrial, the very first time you met with anybody after the charges were levied against you, and you met with somebody, that's when you were pregnant. Is that correct?
Correct.
All right. The state understands now. So, Your Honor, for the record, she was pregnant at the pretrial,
Okay,
not
that
at
makes
the
sense.
probation.
Okay. All right, back to you, Ms. Cawthon. Anything else you want to add before we pivot to me and I do my part?
I also did serve jail time when the incident happened as well. I forgot to mention.
How much?
I don't know right off the top of my head. I don't know if there's a way you can look at that in the system. I just know that I did, I think maybe 3 or 4 days, possibly. I was 17 when it happened.
All right. Okay. Anything else?
No, Your Honor.
I'm counting days. Give me just a second. Okay. All right. You ready? All right. Here's how it's going to work. You're telling me you're leaving town on June 17th. I am revoking 43 days to serve. You will turn yourself in if you are still here in Spalding County on June 18th to serve those 43 days.
So may I ask,
If you-
what does that mean, Your Honor?
It
If you
means
can break it down a little.
it means you need to move away and not come back.
Yes, Your Honor.
It means that I think you need to do jail time, but at the same time, you've been pulling us along for all this time. I'm factoring in the mitigating factors of this case. And I'm simply saying that this is my balancing point. You can either stay here in Spalding and do 43 days, or you can move off and start a new life somewhere else. And whichever
Sure.
of those you choose is your business. But if I find out you're here in jail, you're here in Spalding on June 18th, or you come back at any point after that, then your 43 days starts the day you step back into Spalding County.
Yes, Your Honor.
You need to go, you need to put Spalding County in your rearview mirror, and you need to start your new life somewhere else. Okay? Do you understand that if you come back to Spalding County, I will issue a warrant and I will have you taken into custody? And you will serve those 43 days. They will be waiting for you. Yes?
Yes, Your Honor.
Okay. All right, go pack your bags and move away. That time is of course suspended upon proof of that she's gone. You need to mail proof of your new license to the Sense Enforcement team, ma'am. You need to mail proof of your new residency to Sense Enforcement, showing them your new address.
Yeah.
No, I'm just send her up. Oh, yeah. Sorry. Margaret, hold on just a second. Margaret, you can go get her before she gets away. All right, we're done with that one. Okay, what's next? That's your last probation matter?
Yes, I mean, we have Ellis. It's a modification, but.
Who's our mod?
Yeah.
I am. Ellis? Ellis? Where are you? Come on up. So, okay. So, suspended on out of state balance. Okay. All right. Sir, state your name.
Jamal Ellis.
All right, Mr. Ellis, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Never true.
Yes?
Yes, sir.
Okay. Mr. Ellis, what is it you're looking for from me today?
Nothing really. I thought the paper that I signed.
You're being a little quiet. That's all right. We'll figure this out. It's gonna be all right.
Yeah, the paper that I signed, right? I thought it was gonna work out for me, but I got a lot of appointments. Then my old lady, she got appointments week after week, breast cancer. So I thought I was gonna work out. So I just want to change it to, some weekend, something.
Okay. So you want me to remove you from the probation and convert it to jail time?
No. No, what I'm saying is, I know I signed for it the first time. Everything on like the appointments, all the appointments and all that, it's getting better. It used to be back every day. It's like every day, like Monday, Tuesday, Thursday. I'm going back and forth to Piedmont. And all
Oh,
that.
your
And I
consent
got-
order.
And I got to work.
You're talking about the consent order that you signed on May 4th.
Yeah, from a community servant. So
Got it.
It can go back to it. It's just that at first, it was just back-to-back appointments. I couldn't make them community service, so I got you about 20 hours, something like that.
Okay, okay. All right, so let me just say out loud, what's going on at this moment is I have your consent order pulled up in front of me.
Okay.
And that consent order, was that signed here in the courtroom or out of the jail or
Courtroom.
courtroom? And this was to avoid the hearing with me back on,
Last week. About
last
2 weeks
week.
ago. Yeah, 2 weeks ago, last week.
no, yeah, no, there it is on the 4th.
Yeah.
Okay. Anything else you want me to know?
No, that's about it.
Okay.
I just want to change the decision, that's all.
So the way, I mean, the way these consent orders work is I've said, and I say it every week, which is that they're a take it or leave it option.
Yeah.
And if, unfortunately for you, if I were to allow you to do what you're trying to do today, what would happen from my perspective is that everyone who wants to avoid a hearing with me could sign it and then leave, and then come back and ask me to change it. And that would mean that nothing would ever get resolved in this court, which means I cannot possibly do what you are asking me to do without upending my entire court process.
Yeah.
So what would have happened at that point is we would have had a hearing. And from the allegations that I'm reading, there was a pretty decent shot you would have gone to jail. I would say it's greater than half. And I also signed a stack of warrants this morning, and I kind of think I saw your name in there.
Yes, sir.
Okay, so before we even got started, they already presented me with a warrant. Do you have it there handy?
What?
That says that you failed to comply with the terms and conditions of the consent order that you signed.
Oh, yeah, that was from last week.
Yeah, so like we didn't even make it to here. So, so here's what we're gonna do. So again, this is, I cannot allow this to move forward. Now, that doesn't mean you go to jail. But it does mean that there was no way in God's great green earth I would make the changes. So if I didn't have this warrant in my hand, what I would say to you is, Mr. Ellis, you need to go do it, or you are going to go to jail, because that's what was about to happen when you signed the consent order. But they've already presented me with this warrant for your arrest this morning in a big stack of stuff that I signed and gave back, and I saw your name in there. And so I am going to have you taken into custody on this warrant, and you will be presented with a new consent order, and you can sign that one or have it here. So, but as far as that last consent order goes, because Deputy Cersei is putting handcuffs on you, you can forget about, you don't need to worry about those terms anymore that were not working for you, because those terms, that consent order is now gone.
Okay.
You have a fresh start to figure out what's going to happen next. And they will present you with a new consent order with new terms, and you can sign that one or not. And I will just tell you to be much more careful when you sign or don't sign the next one to decide if that's what you want to do. Okay?
Got it.
All right. This is not the outcome you wanted, but it is the outcome you got. And again, I have no intentions of allowing people to renegotiate consent orders. I want folks to either have their hearing or not. All right? Deputy Cersei, he's all yours. All right, thank you, Mr. Ellis. Your request for modification for today is denied. All right, what else you got?
That's all as far as probation.
Okay. Okay. All right, so let's look back through the calendar and see what else we got. So I've got page 1, we're finished. Page 2, we're finished. Page 3, we're finished. Page 4, we're finished. Page 5, we just have Mr. Stringer. And page 6, we're finished. I still have a lot of folks out in the gallery. Raise your hand if you're here for community service work. Yep, and yep. Okay. All right, you're here, sir. Beard, you're here for. Oh, I recognize you now. I'm so sorry. You're good. Grab a seat. Thumbs up. So sorry. Had too many plates spinning and some Led Zeppelin lyrics in there, and none of it got worked out. All right, Mr. Stringer, come on up to the table here with whatever it is you need. Actually, just bring all your stuff with you, please.
Yes, sir.
And Terry, this will be a transcript.
Okay. No, sounds good.
You ready, Ms. Sexton?
I am, Your Honor.
Mr. Stringer, raise your right hand.
Yes. Yes, Your Honor.
Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, take your hand down, state your full name for me.
Christopher Stringer.
Mr. Stringer, you are here today on the court's notice of indirect criminal contempt, as well as a bond modification or bond status review would be the way I would call it, on 25 SR 0282. I'm going to place on the record why this is here, and I also need to put a few things on the record from you. One of which is that, do you understand that there are 2 hearings being simultaneously conducted based off of the same evidence? Yes or no?
Just for clarification, you said the bond and the contempt?
That's correct.
Yes, Your Honor.
Do you understand that the standard of proof for contempt is the same as any other criminal jury trial for guilt or innocence, which is proof beyond a reasonable doubt?
Yes, Your Honor.
Do you understand that the standard for a bond status review is the much lower standard, which is preponderance of the evidence? Or if these were the scales of justice, it would be 50.1%. Do you understand that that's the standard of proof on the bond modification?
No, Your Honor. Can you clarify that a little bit more?
So there are multiple standards of proof. One is beyond a reasonable doubt. You're with me on that one, correct?
Yes, sir.
Beyond a reason to doubt.
Yes, sir.
The other one is what's called preponderance of the evidence. The way I would explain preponderance of the evidence, which is the same standard as a civil case, which is you take the scales of justice, and for the record, I'm holding my 2 hands up like they're the scales of justice. Beyond a reasonable doubt would be this, and I'm holding one hand up high and one hand down low, way low, and I'm now going back to preponderance of the evidence, and I'm just going to move my right hand a little bit up and my left hand a little bit down, so that you'll see one is slightly higher than the other, and the other's slightly lower than the other. That's preponderance of the evidence. That's the standard of proof for me to decide a bond status matter. Do you understand that now?
Yes, Your Honor.
Okay. So that's what we're doing today, is 2 hearings at the same time. On the criminal contempt matter, you understand that you have the right to have an attorney represent you.
Yes, Your Honor.
And you are here representing yourself.
Yes, Your Honor.
And we have been over this ad nauseum
No, yes.
about
yes,
your
sir.
rights to be represented.
Yes, Your Honor.
And you have hired and fired multiple attorneys. Is that a fair statement for me to say?
Yes, Your Honor.
Okay, because you had the public defender's office and you fired them in open court, correct?
Yes, Your Honor.
And then you hired one of the local premier defense attorneys, Mr. Singleton's office, and then you fired them after they filed their motions.
Yes, Your Honor.
Okay, so there was a pause there that I'm trying to unpack in my head, which is that you paused when I said you fired multiple attorneys, because I just thought of that as a very easy factual statement, and I'm a little concerned about that pause. Do you want to, do you need to unpack that, or is there something I'm missing that caused that pause?
Yes, Your Honor. And it's just, I'm not quite here to address that. I'd rather address, the situation at hand.
What you want to address or not is of no concern to me.
Okay, yes, Your Honor.
We're here to address what I want to address. So I'm sorry that that is something you don't like, but I honestly am not concerned about that.
Yes, Your Honor.
So only one of us gets to run this hearing, and it's
Yes, Your
not going to be you. It's
Yes,
going to
Your
be me.
Yes, Your Honor.
So we're going to address what I want to address. Do you need to address anything else about your hiring and firing of multiple law offices? Because I don't want to hear later that you didn't understand about your rights to represent yourself versus your right to be represented by an attorney. So this is your opportunity to address that if you have any questions or concerns.
It's a difficult process. I'm trying to figure this whole process out myself. And
Well, how about this? I'll just ask some very specific questions and that'll get what I need on the record.
Yes, Your Honor.
You understand you have the right to have an attorney represent you at this hearing.
Yes, Your Honor.
You are sitting at this table by yourself. There is no one there with you.
Yes, Your Honor.
You are currently unrepresented. Is that true?
Yes, Your Honor.
And you are currently wishing to represent yourself at this hearing. Is that a true statement?
Yes, Your Honor.
Okay. Well, then I have what I need. And is it your intention to continue representing yourself as we move forward in this case, or do you intend to try to retain additional counsel?
I represent myself, Your Honor.
Okay. Well, then that's what I need to consider. So I'm going to put that it is my obligation and responsibility to review on the record at this contempt hearing that it is a criminal, indirect criminal contempt hearing where you have the right to have an attorney represent you.
Yes, Your Honor.
And you have elected to represent yourself and move forward. And I'm going to find, because we've already done this several times, that you are knowingly, voluntarily, and intelligently waiving your right to representation and demanding to represent yourself. Is that a fair statement, or do you have any objections to that ruling?
No, Your Honor.
Okay, then we're good to go on that. The maximum punishment I can give you for this indirect contempt hearing is 20 days to serve in the Spalding County Jail and or a fine. Do you understand that that is the maximum possible sentence I can give you on an indirect criminal contempt case?
Yes, Your Honor.
Do you understand that as a bond modification with the much lower standard, I can actually make a lot of changes to that, including the revocation of your bond, but I don't have to do that beyond a reasonable doubt? Do you understand that the standard is lower?
Yes, Your Honor.
Do you have any questions you want to ask me about this criminal contempt hearing and this bond modification hearing about anything to do with that before we step in?
I had kind of wrote everything down so I could be quick and to the point for you.
Okay.
Is that okay?
Yes.
Okay. Did you want me to go ahead and read it now, or?
I don't know what you're about to do, and so I'm trying to figure that out.
Yes, Your Honor. I'm just saying as we proceed, I just have, as I'm making my statement and going ahead with this, I try to write everything down so it's to the point, so I'm not kind of going back and forth to make it easier for you. And I just want to ask permission to reference that if necessary.
You may open your folder and reference whatever it is that you need to reference to feel confident that you are appropriately tracking and responding to this moment.
Yes,
Now, the state did not file this motion for contempt. I did.
Yes, Your Honor.
And I did because it was brought to my attention that you, while represented by counsel, appeared at the clerk's office and attempted to file a thumb drive. Thumb drives are not proper for filing in the clerk's office. Now, I got just enough information. You need to know I am not fully briefed on all of this.
Yes, Your Honor.
What I know about this case is what I'm telling you,
Yes, Your
which is that there was a back and forth with you and Ms. Evans, who is present here in the courtroom,
Yes, Your Honor.
about your attempt to file this thumb drive with something on it. And that you were told, I believe, that such a filing of such a thing is not proper with the clerk's office. You were also trying to file a piece of paper, and we are of course, trying to steer towards, when we've been steering towards e-filing since 2016.
Yes, Your Honor.
And from my understanding, you are arguing with the clerk or disagreeing with the clerk or whatever you want to characterize it as, and that your result, your decision of that moment was to write something out and abandon the file, the flash drive, and that document in the clerk's office saying you filed it, and that they came out to try to get you before you left to try to get it back, and that you refused to take it. That took up significant bandwidth in the clerk's office, disrupted the orderly operations of the state court clerk's office, which is an extension of this court. When I was notified of it, I filed this. And I'm just letting you know, I just don't want you to assume that I know things I don't. I've given you what I know. Now, I have more information now that you filed it, which is, it's very clear to me when I read your response that you have some sort of recording that you made of this interaction with the clerk's office. Did I understand correctly that you have some sort of audio or video recording?
I have it on record, Your Honor. Yes, sir.
Okay. I'm going to ask my question again.
Yes, sir.
Am I correct that you have an audio video recording of this interaction that you had with the clerk's office?
No, sir. I have a picture that I had taken of the I had a picture that I had taken of the actual filing that I had made, because I said I was gonna write it out. And then I just had the transcript, the audio of the interaction.
So when you just said, no, you don't, and I said, do you have an audio or video? The correct answer would be that you have an audio recording of the interaction. Is that correct or not?
Yes, Your Honor, is
Okay,
what I'm saying.
because you made it very clear in your response, because I read your response. You filed it, you wanted me to read it, and I read it.
Yes, Your Honor.
And it was very clear to me that you have some sort of recording of this. And you're telling me it's not a video recording, it's an audio recording.
Yes, Your Honor.
Okay. All right. Have you provided a copy of that audio to anyone, or have you held it within your own file?
I was talking to Miss Sexton. She was saying that she can't receive it via USB. I said I could send it to her via email, but we wanted to wait on your approval of or when we were going to do that.
Okay.
Can I comment?
Yes, and just 1 second. So, because I'm going to come over to you in just a second, let you fill all this in. Okay. All right, Mr. Stringer, is there any other housekeeping you want to address with me before we jump into the facts? Again, the facts I gave you were just so that you can understand my knowledge basis as we get started. Do you have anything else we want to address before we jump in, before I hear from Ms. Sexton, and then we jump into the actual hearing itself?
I guess I'll make those statements when it's my turn.
Yes.
Yes, sir.
Again, this is a housekeeping moment.
Yes, Your Honor.
All right, Ms. Sexton, the floor is yours.
So I'm not exactly familiar with the way this hearing should go. Can I make an opening statement?
Yes, yeah, we're going to get to all that. This is all just the housekeeping for me to understand for me to put on the record the context of how we got here, for me to address his rights to have an attorney, to explain to him what the maximum minimum punishments are, and to make certain that the record is clear as to what his risk exposure is here. In just a second, we're going to pivot to the actual hearing itself, and we'll start with opening statements.
So I'd like a little housekeeping.
Yes, that's what we're doing. Go ahead.
I'd like to ask Mr. Stringer at this time, if at any time on today's date that he has been recording either audio or visual in this courtroom, prior to this courtroom, my discussion with him prior to the hearing.
No, ma'am.
Okay, so you currently have no audio and or visual recording device going on at this time?
No, ma'am.
All right. And just so you know, we are live streaming this to YouTube. So obviously, if you decide you want to look at it later, you can look at it later. And if you want to get a copy of the transcript from Ms. Terry, you may purchase a transcript from Ms. Terry, but you are not allowed to record without permission of the court in the courtroom at any time ever, whether or not I'm on the bench.
Yes,
So
Your
do you
Honor.
understand that when you're in public spaces, just to be really clear,
Yes, Your Honor.
when you're in public spaces, you are allowed to record?
Yes, Your Honor.
Whether or not it's good form is irrelevant. It's whether or not it's legal or proper.
Yes, Your
And the answer is when you're standing in a public space in the courthouse, you may do that. But when you're in the courtroom inside these four walls, whether I'm on the bench or not,
Yes, Your
you
Honor.
are never allowed to do that without my permission.
Totally understood, Your
And I
Honor.
would very likely give you that permission if you ask it at the right time, in the right way, with the right equipment that's not going to be disruptive. But I'm also going to tell you, Miss Terry is here taking this down and I live stream it to the internet. So I'm just letting you know that that's what we generally always do.
I didn't, can I speak, Your Honor? I didn't know that you streamed it to YouTube.
Yeah, Spalding County State Court.
If I go on YouTube, can I see the other,
I don't know what I do and what I
Okay.
don't. We've had, in the transition, I have had some significant technical difficulties and I've had several sessions that got missed.
Yes, sir.
So was yours missed? I have no idea.
Yes, sir.
You are welcome to go hunt for it.
Yes, sir.
So just go look on the days you're there. It's up on the date and it's listed by date.
Yes, sir.
So, but I do try to put every court date up there, but we did have some significant technical difficulties as we got started.
Totally
All
understandable.
right, Ms. Sexton, anything else?
No, I would just like to clarify, that there were two issues here, and one is, about tapes, and I just want to make sure that we're clear on this. There is an issue regarding a tape, which was a recording device, a recording which occurred, from a police apprehension arrest. That's not what we're talking about today when I'm referencing this next little bit of conversation. Prior to this, I approached Mr. Stringer and basically said, I did not subpoena your recording. However, if we want to streamline this, if you have a recording of this and you want to show it to the court and you show it to me, we can do this ahead of the hearing so we can just figure out what's going on. And Mr. Stringer said no,
No.
which he,
Don't. Put your poker face on and you better keep it on.
Yes, Your Honor.
Don't do that again.
Yes, Your Honor.
Go ahead.
which he is entitled to do. I was not mandating, I was simply asking to streamline, because this whole case has been an example of inefficiencies as far as trying to handle a case. So it was simply my request, can I look at the tape? He has a laptop. I didn't ask for it to be emailed to me, to be sent to me. Can I see it on your laptop just so we can figure out what it is that you're trying to say? And that request was, he did not want to do that, which is fine, but I want to make it clear that it had nothing to do with the security, because I asked him if he brought his laptop. which he brought. So that was not the issue. I don't want that to be misrepresented, Your Honor.
Okay. All right. I think that concludes our housekeeping. We ready to jump
Yes.
in? All right, Mr. Stringer, anything else before we jump in?
Yeah, I just want to put on the record when, to my understanding, what you were saying when you had approached me was that, if that she had an understanding that there might have been a recording and that, if we wanted to take a look beforehand, if we can do that. And, I was trying to figure out if it was, if I needed to send it to her via email or what we were trying to figure out. But I was trying to make it, I want to make it clear that, I was trying to say, if you want to see it beforehand, yes, you can.
Okay, so you're offering to make it available?
Yes, Your Honor.
And how would you share it? Dropbox, Google Link? What's your preferred method of service?
Whatever is easiest for her. Last time I sent her the video via Gmail, but
Okay.
whatever.
Well, if you got a Gmail folder that the state already has access to, drop it in there. And even if it's after the hearing, drop it in there so that they can have a copy of it. Because if you do present it at the hearing today, they'll need a copy.
Yes, Your Honor.
Okay. All right. Anything else?
That is it, Your Honor.
All right. I have misplaced my legal pad. I'm going to go grab that real quick and then we'll jump in with Ms. Sexton's opening statement. Okay, Ms. Sexton, the floor is yours.
Your Honor, I'd like to place some context
All right, the opening
on-
statement's
on
all
this-
yours.
on this situation. From the beginning of this case, the court has offered courtesy and grace to the defendant. The defendant appeared extremely late at a court date of 2/1/25, and a bench warrant was issued. When he explained that he had been stuck in traffic in Atlanta, the bench warrant was lifted. Subsequent to that, even though it was late in the game, the judge reviewing the court transcript, and it was you, Your Honor, because there are two judges involved, it was you and Judge Esri on one of the other hearings. You offered for him to go see the public defendant. And even though it was a little late in the game, you suggested that he go see the public defendant. There was some confusion about an obstruction charge and merging charges, and you suggested that he see the public defender. As you are aware, he then hired the public defender. As you are aware, Mr. Charles's credentials are pristine and are full of integrity. And because later in the game, Mr. Charles consented to a continuance, which was going to be automatic by the court anyway, as each side was allowed a continuance. Mr. Stringer in open court insisted on being heard after Judge Esri had granted the continuance. And that was Judge Esri gave him time to speak. And again, it was a long protracted discussion about what was going on with this case. And even though it was not properly filed and it was not properly done, Judge Esri granted a speedy trial. The format of the filing of the speedy trial was incorrect. However, he was kind enough to grant, again, another courtesy that the court was given. Second of all, well, I'm not sure what number we're on, but then again, when there was a request for a speedy trial, even though Your Honor could have insisted that that not be adhered to because it was not properly filed, again, you extended the courtesy of giving him a speedy trial because Judge Esri had done so from the bench. This is where all niceties on the defendant's side have lapsed. The state has been accused of withholding evidence. The state has been accused of lying about the availability of their witnesses. And the state has been accused of all kinds of misconduct regarding discovery, so on and so forth. The state has expended a great deal of time investigating these situations, trying to answer these situations, and rectify these situations. It should also be noted, and this is in a court transcript, that the whole reason we're here today is because the defendant wanted to file a thumb drive with the court and had already acknowledged that the thumb drive had been given to the state by his attorney, George, at the Singleton firm. So I'm not sure why this was absolutely urgent and requiring a filing, which cannot be done anyway, and why the defendant, who claims in his filings that his actions were in good faith, were not willful, and were based on confusion. the state will prove that that is not what happened in this case. It should also be noted that while it is not illegal to record an interaction that occurs in public, it is bad form, especially when the other people do not realize they're being recorded. And just because somebody does not raise their voice, and just because somebody does not get loud, does not mean that they are not disruptive, that they are not rude, and that they are acting in a way which is demanded by the court. There was a court order that Carly was obeying as the filing clerk, and in a contempt charge, if a court order is willfully ignored, then that's the basis for a contempt charge, among many other bases. But there was an e-filing order filed on 7/6/2018 regarding the fact that all cases in criminal court, which is the court in question right now, there were other cases that also had to be e-filed, but we're talking about a criminal case right now, that had to be e-filed. So it's the state's position that there was a valid order, which Carly was aware of as an employee of the court, that she had to obey, and that she was simply telling the defendant that she could not accept it per the court order. There were other reasons why she was told she could not accept it. Another being that we had just had a very serious security risk, and no flash drives were being accepted as being entered into evidence. And thirdly, there was a genuine issue regarding his representation, as he had not, the defense counsel had not been properly withdrawn from the case. All of these things were issues that fall under contempt, but the state plans on proving that it was a violation of the court's order, it was willful, and despite what the defendant has argued, that this was not a good faith attempt or a situation of confusion.
All right, thank you. All right, Mr. Stringer, floor is yours for opening statement.
Yes, Your Honor. Your Honor, I hope you don't mind if I, move back a little bit as far as,
Sure, just let John move the mic so Terry can keep up with you. And again, you're welcome to sit or stand. You're welcome to go to the podium. It's important to me that you be as comfortable as you can be in the courtroom while you're making your presentation.
yes, Your Honor, and
Just
also,
stay near the mic.
I'll stand just to, show respect, Your Honor.
No problem.
I want to start off by saying, I have written down, like I said before, I have written down everything that I'd like to say. I was going to talk about just what's here at hand, but Ms. Sexton has, taken it a little bit farther back. So I would love to appreciate, I'd love to answer or respond to the issues that she had brought up. As you know, this is a case that began in 2024 on December 15th. Ever since then, I haven't needed it. This is not a city that I live in. I live all the way up in Duluth. It takes me an hour and a half to 2 hours to get here every single time. Yes, I was late one time. That is because I have to Uber here. And the Uber, I left at 6:30 in the morning, and I still didn't get here until after 9, which was what made me significantly late because, as we know, Atlanta does get traffic and gets very heavy traffic from time to time. And so I was considerably late. But I also did call ahead to the courthouse to let them know that I was going to be late. Also stating from that, I've had multiple, knowing that and how far it is, it's about a $150 round trip is what I pay every single time I'm here. As we know, I've been here multiple times, and I am, I was late one time, so I'm here um, showing that I show up and to present myself and respect your time as well. What she had also mentioned was moving from that point, saying, I've had situations that have been extended to me. Um, as far as, the speedy trial, and then also your recognition of the speedy trial as well. That came from when I met in front of the judge on the 16th of March, that we spoke about, and I told him what I was going to file, and that I was asking him to grant the speedy trial, and he accepted that request. As far as filing, I told him I would file that afterwards, so it was done properly, and so that it is following the orders. From as far as actually being attentive to the court's needs, I have also acknowledged that, I have had filings that have been declined, just because I have said in filing it via the web or online that, I was going to hand it in person. And that has been denied because I did file it online instead of handing it in person. So, I've been respectful of the court, heard all the court's, decisions and rules, and I've abided by those. And when those were denied, it was, I didn't make a big deal of it. They were denied. Okay, and we moved on. And as far as when we're going to talk about the Jukes firm and how they were able to represent me. Me and Mr. Charles had a conversation beforehand where he wanted me to accept the plea that they were offering. This is all before. This is all after he said he had received the evidence of the video that they had obtained. When they obtained the evidence, when I asked him if they had the video, he said yes. He said, I need to plea. I said, I haven't seen the video as yet. He said, it doesn't matter. You need a plea. Yeah, you won't make it on the stand. I said, I would, love to see it. I also told him that I did not want the continuance because of the matter at hand with my custody case. With the custody case, not having a license definitely affects you. And as I was researching and seeing all the evidence, I thought my case was valid. Now on that, I had Mr. Charles compel for discovery. When he compelled for discovery, Ms. Sexton and her team, what they provided was the physical documents of everything that had happened, as far as the statements, the witnesses, the statements from each officer, where it happened, what happened, and the things of that sort. When I received that, I let Mr. Charles know, hey, I had my ALS hearing, which is why my license is suspended and has been suspended since July of last year. That, they showed me a video. So I know that they have a video. Can we ask to see if we can get the video? To which he responded, we have to get the video. To which Ms. Sexton and her team had provided to them a video. And this video was, when I had finally got the chance to see it, this video, the only thing the video had showed was the last car approaching at the very end, pretty much when I was already being taken away, and it showed nothing of what had happened. And so, I told Mr. Charles, hey, number one, you compelled for discovery, and at first they said that that's all that they had. Told him that they had more, so he asked for more, and then they finally came back and provided that video. Um, After that, I from then, I had asked Mr. Charles to, begin to dismiss the case because that's all they had, and it didn't show what was necessary to provide the necessary things needed for the things that they were charging me for. From that instance, moving forward, I had asked him, I want to get this done. I have custody. Let's get this done right away. I don't want this to drag out. Let's get this done. From there, yeah, I showed up to court on time, and I was discussing with one of the other attorneys the options, and they said, here's some things that they're providing. Here's what they're asking, and I was explaining that, hey, I have proof that that goes against what they're saying. And at that point, as I was talking to her, Mr. Charles came out and said, we're getting a continuance. And I said, Mr. Charles, I can't do a continuance. This is going to affect other things. And so at that point, I let him know that I did not want the continuance. Unfortunately, when he stood up in front of the judge, when the judge had called my name, he still asked for the continuance. At that point, asserting my rights, I let him know that I do not want the continuance. At that point, he turned to me and he said, I am your attorney. What I say goes, and you're getting the continuance. At that point, since he wasn't doing he wasn't asserting what I was asking him, and he was pretty much doing what he wanted. I said, Your Honor, I'm sorry. I'd rather represent myself than go with the continuance that can further hinder my obligations, especially trying to be there and provide for my daughter in ways that she needs. So moving forward, although she says that I've been given all the niceties and things of that nature, we also know that moving forward that I moved forward with the Singleton firm. I let them know that, hey, I want to do this the right way. Hopefully we can get this done quickly and easy. I said, hey, I handed it to him. I said, I'm hoping this is going to be very, very easy and the easiest case that you guys have. When we spoke, they had agreed, and they were doing the right thing. They had also filed for a continuance. At that point, we talked when Miss Hudson was in here. I talked to her. I said, "Hey, Miss Hudson, I do not want the continuance. I cannot do the continuance." She said, "Okay," and that's when she took away the continuance. At that appointment, or at that hearing, I'm sorry. Although Miss Miss Sexton and her team had already been granted continuance, and you said everyone is granted a continuance, at least one. She asked for another continuance as well, and the continuance was for an officer that she said was on FMLA leave, to which I took it upon myself just to verify and make sure that everything was fine. Just because in the past she said that she had given me all the evidence that she had before, and I was able to obtain another one. So I wanted to do my due diligence and just confirm with the open records that the officer that she stated was on leave, because I knew that there was 4 things that she had to prove in order to get the continuance, which was the witness is truly and materially truly material, and their testimony cannot be obtained from any other source. That she did her due diligence to use that and to secure the witness attendance. The witness will actually be available at the continue date, and the facts that that he could not testify, that his I'm sorry, the facts that he would testify to are not provable through other witnesses. Um, we're not we're said to be um, uh, were said to be true. So upon my due diligence of asking the open records if he was on FMLA leave, um, they stated that he was not, and that he was on active duty. Active duty, and I said, "Is he currently Is he on active duty and currently working?" And they said, "Yes, he is." So this is just another rock in the road that has further delayed everything, the entire case of what has been happening. So as far as niceties, um, I have showed up. I have, except for one time, I have been on time, regardless of it costing me $150 at least round trip, just to make sure that I am here every single time. I've gone out of my way to hire attorneys to try to make this quicker and easier so we could get done with this. Um, uh, and unfortunately, when I presented that information to Miss Hudson, I asked her just to simply put it on the record. Not even the fact that she had to challenge the not it, that she had to challenge the continuance, but at least put it on the record. She refused to do that. I felt it was at least my right to have that on the record, knowing that I had asked for right to speedy trial, and and to show that I am, on my part, I am doing everything to get this trial done. Yet uh, Ms. Sexton and her team have been allowed multiple continuances, more than what I was told is that the court normally allows. Um, upon that, I was this this recent incident came up from, yes, Miss Hudson and her team, the Singleton firm, had filed motions on my behalf. Um, I did not know that they had filed the um, the video via that they had filed the video via however they had filed or so you say that they have filed the video with you. I knew I wanted to get that on the record because at the trial, at one of the hearings we had, you yourself, Your Honor, said that if you found it, and you listed, what the Brady violation was, and if you found that that was true, that you would dismiss the case. So I wanted to make sure that you had that in your hand, so that you did have that ability to do so. As Unfortunately, Ms. Hudson had told me that the last date to file was the end of April. Knowing that it was the last day and communication had been delayed, I wanted to make sure that everything that could be filed was filed. So that is why I try to have a pretty in-depth conversation with Ms. Hudson to um, have the fact that even if it wasn't to challenge the motion, at least the FMLA um, open records conflict was at least put on the record. Knowing that that was the last day, I knew I had to at least make sure it was done. although being in a rock and a hard place, you know, the whole reason I was able to get the video in the first place was unfortunately I had to represent myself in the custody case, to which is where I was able to get the video that I had of the body cam that Ms. Sexton and her team did not provide and said that they did not have. So I, having represented myself before, I felt wanting to make sure I got everything on the record that I could do that. Now, when it comes to this case, like I said, I am doing everything I can to stay within the what is demanded of the court, and I wanted to make sure that I was doing everything in a way that I could respect the court as well. Knowing that that was the last day, I went ahead and filed the motions that I needed to at least get that on the record. And that is in that filing, I did go ahead and put in there, that was filed, that was e-filed, saying that I would drop off the video the next day in person. So, and that's kind of what brings me to where I am right now. So that way we could kind of get moving along. Obviously, I have filed a written response to the contempt and plead not guilty. I have an audio recording of the May interaction that directly contradicts the allegations in the contempt notice, and I am requesting permission to present that recording as defendant's Exhibit 1.
Okay. Anything else?
Did you want me to go ahead and present it, or?
No, so do you have a laptop or something?
I could, it's on my phone. I also have it on my laptop, whichever one's easier.
You need, so it's not your turn. We're
Yes,
gonna
sir.
do this, but what we're gonna do first is Ms. Sexton gets to go first because the burden's on her to prove beyond a reasonable doubt that you're guilty of the contempt violation.
Yes, sir.
While she's doing that, I want you to get your laptop out
Yes, sir.
because I don't have the ability to do it from your phone, but if your laptop has an HDMI port, then we can plug it in and push it up to the wall.
Yes, sir.
Okay, all right, go ahead and do that while she's proceeding. All right, Ms. Sexton, the floor is yours to begin evidence.
The state calls Carly Evans to the stand.
All right, so for record purposes, Ms. Evans, as the clerk responsible for state court operations, is seating at the clerk's table. She's moving over to the witness seat, and if you'll swear her in.
Can you give me 1 second?
Sure, yeah, absolutely. Yeah,
I'm so sorry.
well, he's doing that too, so,
Yeah.
all right. And while we're off record, when you get that, when you have it pulled up on your screen, tell me,
Yes, sir.
because I'm gonna try to push it up to the wall as a test run.
Yes, Your Honor. Give me a second. I think I could send it from my phone to my
Yeah, it's
laptop,
fine.
and I'll get there quicker, but my computer's dying.
It's gonna be a minute before we get to that.
Thank you, Your Honor.
Ready, Terry? Okay. All right, so Mr. Stringer, you just keep working on that.
Yes, sir.
I will say, when you do have it pulled up on your screen, just raise your hand and just let me know, and that way I know kind of where you're at. So,
Okay.
Ms. Sexton, the floor is yours if you'll swear your witness.
Is this on?
Probably.
Is it? Okay. All right.
Ms. Evans, will you raise your right hand, please? Do you promise the testimony that you give today is the whole truth and nothing but the truth to help you God?
Yes.
Carly, can you please, for the court,
give us your full name and spell your last name?
It's Carly Allen Evans, Evans.
Can you tell the court your job description or your job title?
I work in the clerk's office, but my title is Deputy Clerk 2 of State Court Criminal.
Can you describe to me some of your duties in court and then some of your duties in the clerk's office?
Inside of court is rescheduling court dates, stamping in orders that the judge files, stamping in orders that the attorney file, stamping in final dispositions, making sure hearings are correct. As far as outside of the courtroom, there's a list, a lengthy list, but accepting e-filings, sending out calendars, sending out notices to defendants, phone calls, checking emails from either the team, solicitor's office, or attorneys.
Would you say that as a general rule, Monday through Friday, you're pretty busy?
Yes, very.
All right. And can you describe to the court how long you've worked in the clerk's office?
I've been in the clerk's office 3 years this month, but officially in the state court division about 1.5 years.
And are you aware of the policies and procedures of the clerk's office?
Yes.
And can you describe to me the policy and procedures regarding criminal filings?
As far as criminal filings, everything is mandatory e-file as of the order that you referenced from 2018. Whether it's an order, an entry of appearance, waiver of arraignment, anything that the attorney or someone pro se wants to file, it is mandatory e-file. So it's all electronic.
Do you have any understanding as to why that's done?
I'm not sure.
All right, that's a fair answer. I'm going to present to you a copy of this order signed by Judge Spafford, dated 7/6/2018. I'm going to hand the defendant, if you'll give me 1 second, we're going to give you a copy of that, sir.
I have that order.
Do you have that order?
Yes, ma'am.
So
Okay.
you're aware of the order?
Okay.
Wait, can I clarify which the notice of
No,
indirect?
that's not the order. Let me make sure I'm giving it to you because I want you to have it.
Omnibus order? Just one minute.
So Carly, I'm sorry, a little off track. Did I give you a copy of the order?
Yes.
Okay, and in essence, is that the order that you've complied with the entire time that you've been in the clerk's office?
Yes.
And in essence, that says that everything has to be e-filed.
Yes.
And would it surprise you to know that one of the reasons for doing that would be that the court handles over 7,600 cases last year and that e-filing makes it a lot easier?
Right. That's correct.
Can you imagine 7,600 people showing up behind the little glass there, trying to hand you pieces of paper and recording devices?
It would
Recordings.
probably make it a lot more difficult.
Okay. Are you also aware of an email that came from the county saying that under no circumstances could flash drives or anything external be accepted?
Yes.
And are you aware of why that occurred?
I believe it was Kyria that sent all of the Spalding County employees an email just stating that there was some sort of breach, that we were not able to accept flash drives, USBs, anything until further notice.
And that occurred prior to Mr. Stringer coming in. That was dated 4/15. Is that correct?
That's correct.
And Mr. Stringer appeared on 5/1.
I believe it was April, yes, 5/1.
Or April 30th, 5/1 or April 30th. So there was a clear mandate that anything that had to be filed would be filed, e-filed. And that under no circumstances would you accept a flash drive for filing?
Yes, that's correct.
Okay. Can you just describe to me about how many people, plus or minus, are in the clerk's office at any given time?
Daily, I would say, obviously it depends on the day, if there's a holiday, but roughly between 50 to 100 people that come through our office daily.
Okay, how many employees are in the office?
I believe it's 17 right now.
Okay. Can you describe, using your own words, what occurred with your transaction when Mr. Stringer attempted to come to the clerk's office and make a filing?
Yes. So on May 1st, Mr. Stringer entered into our office and initially tried to hand me a flash drive. And my initial response was it evidence that he was trying to serve on the solicitor's office because we don't accept flash drives in our office? And he said no. And I asked him to have a seat and to give me a second because I was going to have to go ask some questions. Because at that point, our Superior Court Clerk, Miss Brooks, was not in office. Our Chief Deputy Clerk, Sherry Smith, was not in office. So my automatic instinct was to come to Judge Thacker's office to see what to do. And at that point, Mr. Stringer asked for a piece of paper to try and write down why he was going to leave the flash drive with us. And I told him I wasn't going to do that yet, that he could just have a seat. I needed to go ask some questions before I accept anything from him. So, like I stated, Miss Brooks was not in her office, who is my boss. Our Chief Deputy Clerk, Sherry Smith, was not in her office, who is next down from Miss Brooks. I tried to come in here. Judge Thacker was not here. And then I went upstairs and spoke with Judge Shepard and explained the situation. And we looked into Mr. Stringer's case, and he explained to me that at that moment, Mr. Stringer had filed an injury of appearance trying to represent himself, and Singleton Firm had filed a withdrawal of motion or withdrawal of counsel, but that order withdrawing them from the case had not been signed. So I came back into the office. At that point, Mr. Stringer was not in there. He came in probably 30 seconds after and had a piece of paper in the flash drive and tried to hand it to me, and I didn't take it. And I explained to him that at that point he was still represented by counsel. We cannot accept anything over the counter. It has to be electronically filed, and that he can't file anything pro se because at that moment he still had an attorney. He still had representation. And he went back and forth that I was going to take it. And I'd explained to him multiple times that I was not going to take it. We could not take it. He can't file anything pro se. He still has an attorney. And he asked about trying to give it to the Singleton Firm. And I said that was up to them whether or not they wanted to file it. I have no control over that. And he didn't exactly like those answers. And I told him that he could either try to come back Monday and speak with our Superior Court Clerk, Miss Brooks, or try and speak with the Singleton Firm and see if they would file it. To which he replied something along the lines of, it's an hour and a half to an hour, 45-minute drive for him, and that would be an inconvenience for him. And I just told him I wasn't going to argue with him, that he could come back Monday and speak with our clerk, or he could try to work with the Singleton Firm, but we could not accept the filing at that point. And to which he pushed it through the clerk's office window. We do have glass, but there's a window where we can slide things back and forth, and said, well, I'm going to leave this here with you and file it. And then he turned around and walked out. So I picked up the flash drive and the piece of paper that he was trying to file, went outside, and Mr. Stringer was trying to exit, and I caught Piper and got Piper's attention and explained the whole situation to him. Piper took the piece of paper Mr. Stringer had written on, as well as the flash drive, and put it into the sheriff's safe up front.
So based on your experience as a clerk of the court, was your normal process interrupted?
Yes.
Was your normal process interfered with?
Yes.
Did you repeatedly explain to Mr. Stringer that you would not accept the filing?
Multiple times.
I do not want to hold your feet to the fire, but was it more than twice?
Yes.
Did anyone in the clerk's office observe this?
There were were a few people that were absent that day, but I would say at least 10 of our other clerks were in there watching behind the scenes, and it was enough to draw their attention to the counter, which generally doesn't happen because we have people pass through there daily for numerous reasons, but everyone at that point their attention was towards the counter.
Is this something which has occurred on a regular basis? Someone confronting a clerk regarding a filing?
Not in my experience of being in there now.
In your experience, did any of the words you used or any of the explanations you used or any of the reasons that you gave Mr. Stringer, would they be termed as confusing or not being able to understand what was said to him?
No, I explained myself multiple times and repeated myself multiple times with the same scenario that he could either come back Monday and speak with our clerk, Miss Debbie Brooks, or he could try to work with a Singleton law firm, but that we could not accept it because he was not pro se at that point, and he still had representation. And furthermore, that we could not accept anything over the counter. It all has to be electronically filed.
And based on your experience, did you consider this exchange disruptive?
Yes.
Were you aware at the time that you were being recorded?
I was not.
Is it your opinion that someone has to be loud to be rude?
No.
Is it your opinion that someone has to be loud to be aggressive?
No.
Is it your opinion that someone has to be loud to be disruptive?
No.
And you were simply following a written order by the court and orders by a judge,
That's correct.
that being Patrick Shepard.
That's correct.
I believe that's all I have, Your Honor.
All right.
Am I allowed to object on?
What's your objection?
On hearsay, whether something is.
Yeah, you're not using the
Sorry.
mic. I'm not hearing you either, so.
Yeah, am I allowed to object on hearsay for, saying,
State your objection.
objective
You're
on the.
you're
fact-
allowed to state any objection.
Yes,
and
sir.
My responsibility is to rule on that objection as it's given to me. So
Yes, Your Honor.
if you have an objection, state it, and then I will rule on it.
Yes, Your Honor. Objection to, saying, to the opinion of, someone being, loud or whatever and, being is disruptive or, not, what she was saying.
Okay. All right, anything else to that objection?
No, Your Honor.
All right, that objection. Ms. Sexton, have you finished?
I believe I have, Your Honor.
Okay, all right. So, Mr. Stringer, you may ask questions at this time. And whenever you're ready, we'll play this video. If you've got it pulled up.
Yes, Your Honor. It's the audio. I had the audio pulled up and.
Oh, I said video. I'm so sorry.
All right.
You said audio and I should have said audio back.
Yes, Your Honor. All right. Actually, let me see. I can bring my notes with me.
All right, so before you get started, I'll just say again, nice and slow and loud and clear so that Ms. Scandy can make a good record of this.
Yes, Your
All
Honor.
right, go ahead.
You said your name is Carly, is that correct?
Yes.
Miss Carly, you said that you did see me on May 1st.
That's correct.
I think it was around let's see if I can find that if I have the time down somewhere. But I did come in and I did state that I had upon our initial greeting or initial interaction, I said that I wanted to file the document. I just had the flash drive, and you said, is it correct that you said that you weren't quite sure if I could file it or not, and that you had to go figure out if you could?
That's correct. I asked you to have a seat because I wasn't sure that we were able to accept that at the counter because We are e-file court only, and we don't accept flash drives at the counter.
Okay, yeah, and and I said I will be right back. Do you remember me saying I will be right back so I could, write something down just to help clarify things if that helps? And you said, yeah, that's fine.
Yes.
Okay, and then when first I had asked you for the pen, and then I went upstairs to the library to go grab it and kind of wrote it down in the library, and then came back and went to go turn it into you. Do you remember me? Do you remember me saying when I asked you that you had denied it, and then I had said that I'm not allowed to file it? Do you remember me? You had said that, right? That I'm not allowed to file it.
I remember telling you that we could not accept it at the time because you were still you were still represented by an attorney, so you could not file anything pro se.
Yes, and I had told you I had already filed it and it had been accepted, saying that I was bringing in the flash drive the next day.
I do recall you saying that you filed something the day prior, which was an entry of appearance saying that you wanted to represent yourself and that you ordered Singleton's office to file a withdrawal of counsel, but
do you remember me saying that I had filed something saying that I was gonna filed something saying that I was gonna bring it in already and that it had already been accepted?
I think that was included on the entry of appearance, but just because that's stated on there does not mean that we can accept it at the counter. We can accept the entry of appearance and the motions that were attached to it, but just because you said something on there stating that you were going to file the flash drive or the USB with us does not mean that we have to take it at the counter, because that was not electronically filing it.
And did you ever tell me that? Did you ever tell me? No, Miss, is it okay if I grab this?
Yes.
Miss Sexton had given me the second amended order mandating certain case types to electric filing status. And this is something pretty much saying that I couldn't file flash drives anymore. Did you show me this or tell me that you guys had this?
At the counter now.
Okay. And just want to clarify, are you a judge?
No,
Have you ever practiced to be a judge?
I have not.
And you work at you're the clerk at the counter, correct?
That's correct.
And you accept filings?
Electronically, yes.
Yes. Have you ever accepted filings electronically that weren't ruled upon that said day?
Don't understand what you're asking.
Has someone ever filed something electronically and they didn't have it ordered by the judge that same day? Like have it signed by the judge that same day?
No, if anything, like if we get a motion or a bench warrant lift or anything that comes through our e-file system, we're responsible for checking it, making sure that the solicitor's signature is on there, the judge's signature is on there. So if it's not signed, we're able to reject it through our system.
Yes. But have you ever had filings like that for the judge that weren't ordered upon on that same day?
If you're referring to the withdrawal of counsel, yes.
Well, and not just that, I'm talking about in general with other filings as well.
To my knowledge, the only thing that would have to have a signature afterwards would be the withdrawal of counsel or the order granting the withdrawal of counsel. So
are you saying that the withdrawal of counsel is the only document that you've ever had that was not ordered upon that day?
I don't.
To try to clarify, so if someone files something, does the judge always sign it that day?
Yes.
If I filed an order of withdrawal, he would either sign it that day or not sign it at all.
For withdrawal, they're not always signed the day of, but anything as far as like a bench warrant lift, a null pros, everything, a final disposition, anything like that is signed by the judge the day of.
So you're saying not everything is signed by the judge the day of. Is that correct?
If you're talking about the withdrawal, That doesn't have to have a judge's signature. The order granting the withdrawal has to have the judge's signature.
Yes, but what I'm saying is not everything. If I file a withdrawal today, it's not necessarily signed today. It might be signed at a later date.
The
Is that
withdrawal
correct?
would not be signed by the judge.
Exactly. Oh, okay. So, with that, and I also did state that, it took me about an hour and a half, 2 hour drive to get there that day. And that, I couldn't, you say come back Monday. And I said, I couldn't come back Monday, because of the amount that it costs to go back and forth every single time. Is that correct?
Yes.
Did you know that it is, according to the law, that it is not upon the clerk to make a judgment, but it's upon the judge to make the judgment?
The judgment for what?
As far as like, whether something is ruled in favor of or not. Like, you wouldn't be the one to sign the withdrawal order; it would be the judge, correct?
That's correct.
Okay.
I'm not a judge.
So it's so is it possible that something like, if I was to file an exhibit, it might not get necessarily signed that day. It might get signed at a different day.
An exhibit doesn't have to be signed by the judge.
Okay. So then at that point, we know that although it could be filed, it could be denied by the judge at a different day, or you're saying that an exhibit wouldn't be denied at all. Is that what you're saying?
I don't understand what you're asking.
So when I said that following an exhibit, that it wouldn't get. You said it doesn't need a signature, correct?
Yes, if you're talking about like an entry appearance, motions, exhibits, the exhibits attached to the motions that you filed do not have to have a signature by the judge. That's correct.
Okay. Okay. And so then moving on from there, on the, if you could give me one moment. On the, as far as the indirect continual contempt and bond status review hearing, it says on or about May 1st, 2026, the defendant, Mr. Stringer, while represented by counsel, entered the office of the clerk of the state, the court, and admitted to submit a personal electronic storage device containing alleged advice for filing. Are you saying that everything on here was true?
I don't know. I did not file that order.
Can I give her an exhibit for her to take a look at and determine?
I mean, you're welcome to. I'm telling, I've already put on the record that I wrote that.
Oh, okay.
I wrote those words.
Okay, I apologize.
And that's okay, but I wrote those words after getting just enough information
Okay.
for me to know I needed to have a hearing on it.
Okay.
So you're welcome to ask her about the difference between her perception of it and mine, but I'm just telling you right now, I don't care.
Yes, sir.
Because again, whatever the evidence is today is what will control. That's just more of the charging document.
Yeah.
So, but you're welcome to ask her. You're welcome to show it to her, and you're welcome to ask it. Don't let me stop you. I'm just telling you that's not of that much consideration for me.
Yeah. So,
and I said it's a charging document, but that's not it. It's a notice pleading, for lack of a better term. It's just to get it to you that, hey, there's something we need to sort out here.
Yes, sir.
Okay. I just realized calling it a charging document was the wrong term, and it set the wrong standard. Go ahead.
I appreciate that. Okay.
Again, you're welcome to ask her about it.
Yeah. I just wanted, I just didn't know she had wrote it and I just wanted to get clarification. Just, you know, if
No,
what
I
was
wrote-
put on it.
I wrote every
Yeah,
word of that
yeah, yeah.
document
Okay.
myself.
But moving forward, so, now you say going back to where we were, we kind of went back and forth. Did you make it very clear that, the court does not accept flash drives to me, when you stated everything?
From my recollection, yes, I made it very clear that you still had an attorney at that point. The withdrawal had been filed, but the order removing them from your case had not been filed with us.
Okay, but what I was saying was the actual flash drive, did you make it clear that, that the court doesn't accept flash drives?
Yes, I made it very clear that
Okay.
we could not accept anything that you were trying to file with us.
I was just saying the flash drive thing in general. Going back to the, as far as the actual filing, it is upon you to make sure that the filing is correct and procedurally, correct. Is that right?
We have certain things that we review before we accept them in e-file. That's correct.
Okay. And you knew that although it wasn't granted at the moment, that I was trying to come and file something, that I had, to my understanding, was already filed the day before, and I was just coming in to, pretty much hand in the evidence that I said I was going to file the next day.
Once again, you filed the entry of appearance and motions. Whether or not you stated that you were going to file that flash drive with us, I'm not sure. I would have to review that. But we can accept that electronically, the document, the entry of appearance, the motions. We can accept that electronically. But if you try to file a USB at our counter, that also has to be filed electronically. We cannot accept that at the counter. So
So,
even if you stated that in your document, that does not mean the clerk's office has to accept it at the time that you come in.
and that's what brings me back to, if you made it clear that it was mostly was it mostly the USB document that, was getting rejected, or was it just the filing of it without being represented by counsel? Is that, were you mostly rejecting what I was trying to file because it was a USB drive, or was it because mostly that I was trying to file something while I was technically still represented?
I mean, both reasons. We can't, because you were still represented, we couldn't have accepted it. And because it was a USB, we could not have accepted it.
Okay. And also, I had stated that I did file things online that had been accepted. Is that correct?
Right, because
Okay.
you're obviously familiar with the e-file system since you had prior filed stuff electronically.
And just for clarification, do you know the size of files that you're allowed to e-file? How much space they give you?
Not aware of that.
I believe it's like 5 megabytes, very small. So something that video would not fit inside of. But just wanted to state that. All right. And I want to say that I believe that is all the questions that I have. Do I have to say that I'm presenting the evidence right now, or?
Yeah, if you're ready to play it,
Yeah.
do you have an HDMI cable?
Can I do redirect, or do you want to hear this?
Let me let him play the video. Cause he's tendered it as defendant's exhibit 1,
Sure.
and I'm gonna need a copy of it as well.
Yes,
Cause now
sir.
it's officially, Terry's gonna need a copy. And so, so we're gonna need to sort that out. But, he needs an HDMI cable. Will y'all see if there's a HDMI cable on the bottom? Okay, thanks. So, Mr. Stringer, if you will step over to that little plate there and pull, the one on top of the table, I'm sorry. I should have been more descriptive. There's an HDMI port down in there.
I see it.
So, and that's what I was trying to figure. He just doesn't have an HDMI cable to plug into the HDMI port.
Your Honor, can I ask one more question? Just one question?
Okay, hold. The answer is yes, but
Okay,
hold.
but yeah, just want to make sure it's on.
Can they?
Yeah, that's exactly what
I
I
could use that one.
Hey, Piper. Piper, Miss Sexton has
I
one.
have all kinds of words here you can use.
All right, let's borrow those. Yeah, they should be in that bottom section there, but
They might be out on the tape. I'll go ahead and plug this in, and then can I just ask that last question?
yes.
Let's now let's just say it. I did come back on Monday, and I was to come and try to file. You said I had to file it on Monday, so if I came back on Monday, I would have brought the flash drive. Would I have been able to file it? And if not, would there have been an alternate way that I would have been able to file it?
So I did not say that you had to file it Monday. I said you were welcome to come back Monday and speak with our clerk, Debbie Brooks, because you weren't liking the answers that I was giving you per how we run things in the clerk's office and also per the order that the judge filed with us. So I can't speak for what she would have told you.
Is there a way that I would have, if I can't e-file it, would there have been a way that I could file a video as evidence?
I am not a lawyer, so I do not know that.
I'm just asking as far as a clerk that, reviews the process of how things go. What I'm taking is you're saying that you don't know.
I don't understand what you're asking.
I was just kind of reiterating what you said when I asked if there was a way for me, like, let's say that I knew about not being able to file a flash drive, and I wanted to file this evidence. Would there have been a way other than the flash drive to file this evidence on the record?
So if you're acting as your own attorney, you would have to know how to do that yourself. We don't know how the other end of e-file works. We just accept the filings or reject the filings as they come through.
Okay. All right.
I can help a little bit here. You asked about the size of the filings, and the size is small on purpose, which is that the clerk's office is not a repository for videos.
Yes, Your Honor.
I thought you may want to know this information. which
Yeah,
is that
no, it's totally
The
understandable.
filing size is small because what's supposed to be filed with the clerk are documents. And then what happens with the evidence is you serve it on the other side, and then you bring it to the courtroom, and then you give the court a copy that Miss Terry, the court reporter, will then keep. And that is that's part of the evidence. They're the record. So you'll hear those two terms of art thrown around. The clerk's office is the record, and then this is the evidence. So I just thought that would help you a little bit. I feel like that nuance is not quite, maybe not something you're familiar with.
Yeah, is it okay if I clarify on that?
Yes.
Just because, last time when we did have a hearing, I did try to present the video to you at that time, and you told me I couldn't. I told you asked if I would give it to Miss Sexton. I did say I would. So, in that case of trying to give you the video, and when I was here, so to my understanding, I'm here in court trying to get the video. I was refused, and then I, trying to do it the right way, trying to be respectable to the court. I looked up other ways that other courts do it. For example, like I went online and tried to figure out other ways that people submit evidence like that. And one way that I found was via flash drive. And so trying to respect the court instead of trying to, I had already sent Ms. Sexton the video. So I was trying to, get it to you. Obviously it doesn't fit on e-file. So I took it upon myself to drive 2 hours, really 4 hours both ways to come and, try to respectably try to figure out a way to get that video so that you had it, because last time you had told me that you still hadn't seen the video.
Did you serve it on Miss Sexton by sending her a copy after the hearing?
Yes, Your Honor.
As a matter of fact, I'm not even sure why this whole clerk's office thing happened, because on the record, on the transcript, he acknowledges that his attorney gave it to me.
Okay.
So there should be no reason
Well,
to
I'm
have to.
Hold on. I looked at her because I wanted her to fill me in on this, because I am now I'm a little turned around. So,
I can show you the transcript.
all right, I just want to make certain that you had received a copy of this mythical body camera video that we've heard so much about.
So I want to be absolutely clear, because I think that there might be misunderstanding. When this DUI case came in, our office manager requested video from Georgia State Patrol because that was the arrest, so that was on the paperwork, okay? When she requested video of Georgia State Patrol, and we got that video of Georgia State Patrol, we turned over that video of Georgia State Patrol. The video that he's referring to was never in the possession of the solicitor's office. And I don't know how many times I have to say that, because there's an accusation that yet I still have it and I still haven't given it over. Every single piece of information we had, which was paperwork and video, was given to him. I never had the video. I was then given the video by his attorney, and that is acknowledged on a transcript by the defendant. So why it is that it had to be filed with the clerk is a mystery to me as to why this is even a problem.
Okay, thank you for
Because
that.
there is an insinuation that the reason that it had to be filed with the clerk is because I was not giving it to you to review to see whether or not I had withheld it.
All right, and again, I've been here for all the hearings so far. So, Mr. Stringer, does that help you understand that how things like videos move through the court system?
No, Your Honor. Can I explain on that?
So go ahead.
Now when she said that she said that she had the video, to my understanding, that was the video that she had sent to the Jukes firm, and that was the end.
Sorry.
I was about to say.
And so that was, to my understanding, that's what that was. Now, as far as she said she had the video when we were in court that day when she was asking for the continuance. You said you had also not seen the video. So I was figuring, no one's giving you the video, so I figured I would have to file the video so that way, to my understanding, if you're not able to see the video, how else would you see the video unless I gave you the video? So does that make sense?
Yes, I mean, I understand what you're saying. All right, so let's get back. So we took a little sidebar there to get reoriented. Do you have any additional questions for the witness?
No, Your Honor.
Are
I
you
said
ready
it's
to
just
play it? Because I've got it up here. I pushed it up to the screen. So it's ready for you to mirror it and play it.
Okay.
You said it's an audio? Okay, and again, you will need to get a copy to, you will need to Dropbox, Google, whatever, a copy to us so that Miss Terry will have a copy that she will keep that will go with this transcript.
And can I ask some questions to clarify that?
Okay.
As far as, with number one, I just want to verify if I'm going to be sending this to you. You said that you had the other video. I think you had said I hadn't sent it to you.
Wait, you got to talk to me. In the
Oh,
courtroom, you
okay.
talk to
Sorry.
me. So
I apologize. So I just want to clarify. Ms. Sexton said that I hadn't sent her the video. And I just want to clarify, just so when I'm getting this sent to her,
you should just put whatever it is that you think you have shared, whatever it is you're supposed to share, you should just put it in that folder and just move it on.
And just want to clarify, because she had given me the email address to send it to, so she never received it at that email address. I want to make sure that I do get the right email address.
Okay,
and that
well,
we
y'all
can
can do that after court today.
Okay. And just as far as the other thing, if I'm able to submit this, can I also submit the other video that I've been trying to submit as well? Okay.
Yeah, that's perfectly fine. We'll give it all to Terry, and Terry will keep a copy. And that way this transcript will reflect all that. Again, that's the right way to do this.
Yes, Your Honor.
Okay. All right, go ahead and play your audio.
Okay.
How long is it?
It's only 4 minutes.
Okay, thank you.
Can you hear it? I think it's on.
No.
Can you hear it? Can everybody hear it?
So it looks like your insurance filed yesterday. Let me get it right, lady. So Singleton's office did motion to withdraw.
Yeah.
Actually on the phone. The judge had not signed it, well, just that you're removing it from your case.
Okay.
So you can't file anything pro se until they're officially off your case.
Okay.
So we can't take the USB until they're officially off your case.
Well, I'll leave it here until then.
Because you're trying to file that pro se, and technically, there hasn't been an order moving them from your case. We have to wait for the judge to sign that, and then we can accept pro se filing.
Either way, it goes with what they filed. They needed the video for the Brady's motion
So
as
if you want
well.
to give that to them before the order is filed, that's up to you, but right now, because we still have Singleton's office representing you, and the judge hasn't signed the order for the withdrawal of counsel, we cannot accept anything pro se.
I don't have any,
Yes.
but they've withdrawn as well.
They've withdrawn, but the judge has to sign an order removing order with his signature.
Yeah, but it's the last day to file everything.
We can't take it, if you're technically not pro se. They have not signed an order removing Singleton from your case. So we cannot take anything pro se.
So what if they file it?
If they file it, that's up to them. But we can't take it from you.
The blue one is for places like Staples.
Well, I could file it until it's signed.
No,
Yeah.
no, you can't.
Okay.
You cannot. Not here, not with us, because you still have an attorney. You cannot file anything pro se while you have it.
But they even filed something saying that
I'm not
the
gonna
attorney.
argue with you right now. If you wanna come back Monday and talk to our clerk, but we cannot take that.
Yeah, but I can't come back. It's an hour and a half to get back.
I don't know what to tell you. Our clerk is not here, and we still have your attorney listed as Dwayne Singleton's office. So you cannot file anything per se on your case while you have an attorney.
Okay, can I leave it
No,
here?
you cannot.
And then in the
No.
meantime,
No,
you can tell me if it's rejected or not?
no, if they wanna present that to us, if you wanna take that to them, I think, that's fine.
Well, I'm leaving it here. If you guys want to take it, you can. If not, that's fine.
Can you please,
Yeah. Oh, I gotta go that way? Okay. Thank you. That's it, Your Honor.
All right. Was that the entirety of the audio from start to finish?
Yes, the end of it, there's a couple seconds left. That's just me getting back into my Uber and.
All right. Ms. Sexton, what's your preference on that?
The issue I have is that. Can I ask the question?
Yep. Well, no, I'm asking about the rule of completeness. He's got a couple seconds left. He wants to stop playing it.
I would like to hear, under the rule of completeness, I would like to hear
Okay.
that. And I would also like to make mention that apparently there was discussion before she went and talked to
Okay,
Patrick,
that's a good question.
which is.
Are there additional, is there any additional recording outside of what you've played for me that you're in possession of?
No, Your Honor.
Or that you made and,
Regarding this situation, no, Your Honor.
all right,
As well as any, being in any court, recording, like I had mentioned before, no, Your Honor.
okay, so that is the complete capture of all audio recordings involving this event on that day.
Yes, Your Honor.
Okay. All right, play the last little bit.
Sorry.
I'm in a bathroom.
What's up?
I will not be able to take you back.
Okay. And that was just the end. That was just. I'm actually happy that you heard that. That my Uber driver was trying to wait for me as I was going to go turn this in to help me with the costs. It's normally it's a little bit more. Normally it's very expensive for the Uber there and back. She was trying to give me a little discount, but you know the interaction took a little bit longer, so she was trying to tell me that she wouldn't be able to take me back because it took so long. So I had to offer her some more money to since she had waited for me for so long and to be able to take me back, so I wouldn't be stuck.
Okay. All right. So, any objection to this? Mr. Stringer has tendered this recording, which is 4 minutes and 30 seconds, as D1 for this purpose of this hearing. Any objection to D1?
No, Your Honor.
All right. He's also tendered D2, which is the video of the body camera. Any objection to him tendering D2 so that it's part of this transcript and attached to it?
My only objection, I have no objection to it being as part of this, but I have an objection to the fact that all of these motions have all been ruled on more than once, and we seem to keep going back. Now, I was trying to give some context to the contempt. I wasn't trying to reinvent the wheel. And so I feel like for the sense of completeness, I'm not objecting to it. I just don't want this to be viewed, this to be ruled on. This is a done deal.
Yeah, this is just me. This moment is me giving Mr. Stringer access to the record that he has been trying so desperately to get.
That's fine.
And
The
that's all
state
this
does
is.
not
We're not
know.
watching the video today, but it'll
Yeah.
be part of the transcript and I can watch it later back in chambers and so can you and so can he and,
That's fine.
but it's not,
I
but,
have no problem.
Okay.
The state has never tried to withhold any evidence that they had in their possession.
all right, thank you so much. All right, D1 and D2 are tendered and admitted into evidence without objection. And Mr. Stringer, you will need to provide, you said you have a Google Drive, is that correct?
I have a Google Drive as well. Yeah, I have the Google Drive. I think that
Okay.
would be the easiest because it's such a long video.
Grab a pen and a piece of paper.
Yes, sir.
Ready?
Yes, sir.
All right. All right, we're good to go on that then. Okay, you finished, Ms. Sexton, you may question the witness.
I'm just gonna do a short redirect, Your Honor, because I think we could use a little recap.
So, Carly, what we're here to determine today is whether or not what occurred was an interruption in the process that is associated with the court. And that process would be the filing of the documents and of the drive, which Mr. Stringer bought. That's what we're here today to decide. Did you tell Mr. Stringer more than one time that a filing could not occur?
Yes.
Did Mr. Stringer leave anything behind when he left?
Yes, he left the flash drive as well as a handwritten, I guess, motion that he had handwritten and slid through the counter.
How was this paperwork and drive delivered to the clerk's office?
Towards the end of that conversation, he just said, okay, well, here, I'm going to leave this here with you, or I'm going to file this here with you, and slid it back through the counter, turned around and left. So he just kind of abandoned it on our counter after I told him multiple times that we could not accept it.
So there's a glass partition, there's a little opening through the glass partition, and he pushed it through the glass partition. Is that what happened?
Yes.
And this is not the normal way that filings are done.
No.
And this disrupted.
Yes.
And you spoke clearly that you could not accept it.
Very clearly.
And you had no indication that he did not understand what you were saying.
He did not indicate at all that he didn't understand the process, that the clerk's office couldn't accept it.
And indeed, he has testified that he's been involved in multiple cases with multiple filings.
That's correct.
And he's familiar with the e-filing system.
That's correct.
All right. I have no further questions.
All right. Any additional questions, Mr. Turner?
Yes, Your Honor. I just want to clarify for the record that you were saying that the main reason prior to the audio, you were saying the main reason for the rejection was because it was a flash drive. Is that correct?
I stated because you were still represented and also because it is a flash drive and we cannot accept anything at the counter because it all has to be electronically filed.
And then we also determined that, you know, sometimes things are filed and not necessarily signed on that day. Is that correct?
As far as withdrawals of counsel, yes, that's correct.
And we could say that it was, would you say 4 hours is a short drive? No, I was asking.
I mean, not necessarily, but I don't think that is why we're here.
And as we've concluded that it can be very confusing on trying to file a video evidence. Is that can we?
No, it's not confusing on my part because I know that we can't accept those USB drives.
Okay. But if I was to ask you how I should, before this, when I asked you how I would file a video that size, you said you pretty much.
I don't know because I'm not a lawyer, so that would be
Okay.
up to you if you're representing yourself.
Okay. Now, and last but not least, now when I said that I am. At the end of the video, or I'm sorry, at the end of the audio, I was beginning to walk out, and an officer was starting to say something to me. Is that correct?
From my understanding, yes.
And to my understanding, what I understood the officer was saying was that I was going out of the wrong door, and that I needed to go back and go around to the correct door. Does that seem fair?
That I don't know. I was speaking with Deputy Piper, not the other officer that was sitting out front.
Okay. But what we heard on the audio was the fact that, you know, the officer started to say something and I said, oh, I need to go that way. Did you hear that from the
I
audio?
did hear you say that.
Okay. So could it be understood that, you know, I wasn't, by that, can you understand that I'm not just bombarding my way in, forcing my way in, forcing my way out?
That's overruled. You can answer that.
That I wasn't bombarding my way in, bombarding my way out, that I heard an officer trying to stop me and I acknowledged him, and not just acknowledged him, but repeated back to him what he was trying to say to me. Is that correct?
I didn't say that you were trying to bombard your way through the office or out of our office. I said that you were being not compliant with the rules that we have in the clerk's office.
And when you're saying I shoved something, was it, if I wasn't bombarding my way in, bombarding my way out, was it a bombarded shove, or was it just maybe a more gentle shove?
I think it was an insistent shove that you were leaving that there with us.
Is that what it sounded like on the audio?
There's no video, so we can't. I mean, how am I?
And I did say I was taking a picture of it, correct?
I don't recall that, but
I'm gonna put this. All right. So yeah. So I mean, is it possible that I took a picture of it and then pushed it towards you gently? And then that could have been seen as a little bit more forcibly.
Once again, I didn't say that you bombarded it through
Okay.
our window. I said that you were very forceful and assertive, that you were leaving it there with us and that we were going to take it.
Mhm. And prior to this, you were saying that Miss Sexton was saying that, you know, I don't have to be loud and boisterous to be rude. According to the audio, did you think I was being rude, or do you think I was being more inquisitive?
I don't think that she implied that you were being loud. I think she was implying that you can still be rude without being loud.
And in that instance, do you think I was being rude without being loud, or do you think I was being more inquisitive?
I think you were being very insistent in the fact that you were going to leave it there with us after I told you multiple times that we could not accept it.
But now you're saying that I was trying to be insistent. Was I also asking you about other routes in which I could leave it?
You asked about filing it with or having it filed through the Singleton's office, and I told you if they wanted to do that or if you wanted to do that, that would be up to them.
So that and then your alternative was also that I couldn't file it that day, that I would have to drive another 4 hours on Monday to come and see if I could, just to see if I could file it.
I said that was up to you. If you wanted to come back Monday and speak with our clerk, who is over all of the clerk's office, that you can come speak with her, and I can't. It's not
That's fine. Yeah.
my problem how far you live.
Yeah. But we understand it's, I tried to explain that it was an hour and a half both ways. Well, an hour and a half one way is pretty inconvenient. Is that correct?
You did try to explain that it would be an inconvenience for you to come back Monday, but once again, we can't control how far away you live, and if
Understandable. Yeah, that's fine. Okay. And that's all the questions I have, Your Honor.
You may return. All right, Ms. Sexton, any additional witnesses?
No, Your Honor.
All right. All right, Mr. Stringer, you have the right to remain silent. You also have the right to testify. If you choose to testify at this hearing, you'll come up here. I'll place you under oath. You can then testify. If you choose not to testify, then you have the absolute right to remain silent, and I will not hold that against you in making my decision. You're already representing yourself. We've explored that fully and thoroughly. Any questions about this moment and your decision to testify or not testify?
At this moment, are you saying that the only thing left I have to say is only room I have left to speak is by testifying, or am I still allowed a closing statement?
Yeah, you're allowed to. This is an evidentiary question. And I'm asking you if you want to give evidence in this hearing. Of course, you get a closing argument, but that's not evidence.
Yes, Your Honor.
And so I'm asking you a very specific question, which is, do you wish to provide evidence in this hearing or not?
I've provided those two evidence. Let me see if I have.
I need a yes or a no. Yes, you wish to testify and provide evidence. No, you don't wish to testify and provide evidence. The record must be clear on this question.
Yes, Your Honor. Yes, I'd like to provide more evidence. And would I be able to provide a screenshot of the cost of my Uber ride just here?
No.
No. Okay.
You were able to put that other item in because the witness was able to identify it and lay a foundation for it.
Yes, Your Honor.
The other one, D2, I'm just letting in because frankly, I'm tired of talking about it and this is a good place as any to stick it.
Yes, Your Honor.
And so it has nothing to do with this hearing, but I'm just putting it there because I'm the judge and I can't. And
Yes,
you
Your
want me to, and Ms. Sexton doesn't have an objection to it.
Yes, Your Honor.
But unless you have somebody who's going to lay a foundation for whatever it is you want in, the answer to that is no.
Yes, Your Honor.
And so I'm going to ask again, do you want to testify and be subject to cross-examination on this issue, or do you wish to remain silent, knowing that I will not hold that against you?
Yeah, I would like to remain silent. I think the audio speaks for itself.
All right. Then, do you have any other witnesses that you wish to call in your defense?
No, Your Honor.
All right. Then do you rest?
Yes, Your Honor.
All right. Then there's no rebuttal, which means now we're closing. You want first, last, both, Ms.
I
Sexton?
want last.
Okay. So now we're going to do closing argument. So this is your summation as to why I should not find you guilty of indirect criminal contempt for disrupting the orderly operations of the clerk's office. And you can also address the bond matters as well, if you wish. And then Ms. Sexton will do the same. Go ahead.
Just quickly, can I get a little bit of clarification on the bond matters of how that is coming to be, where the bond matters are coming from, as far as the right to.
The bond matters are here because you were noticed in the indirect criminal contempt notice that I was additionally conducting a bond status review, which is standard for this court.
Okay. So,
And so anytime I bump into something where I'm a little unsure of what I should do with it next, I always deal with the bond status as well, in case I need additional options in my toolbox to bring things back into a forward-facing position so that I can have forward momentum.
yes, sir.
And a criminal contempt hearing by itself does not give me that.
Yes, sir.
And so those of us who are here regularly have heard me say the word bond status review 600 times because that's just what I do.
Yes, Your Honor.
So that's how it's got here, and that's what I'm trying to decide.
Okay. Yes,
All right, floor is yours.
just one moment. All right. I think this would written response helps me kind of get along with it. Your Honor, my attorney filed a motion to withdraw on April 30th, the last day to file motions. I terminated the Singleton Law Group on April 30th precisely because I needed to file materials the firm wasn't filing. I went to the clerk's office on May 1st to file pro se. The clerk correctly told me I could not file pro se until this court signed a withdrawal order. I was physically unable to file for 4 days, not because of anything that I did, but because of the gap between the filing date and the court's own process. The recording proves this. Your Honor, the recording contradicts that about being aggressive. The recording contradicts that entirely. I said hello, I said thank you, and asked repeatedly if I could leave the materials. When I was told I could not, I said, I'm just leaving it here. If you guys want to take it, you can. If not, that's also fine. I was not shoving. That is just leaving the materials when you have no other option. The letter I wrote, which the contempt notice mentions, was written to help try to clarify the situation in a situation that was obviously cloudy. And then at the end of the interaction, I left the courthouse. I've been told multiple times it couldn't be accepted. When you're told something can't be accepted, you leave it as a last resort and leave the building. That's not defiance. That is exhaustion of options. If somebody wanted to call Piper as a witness to what he observed, I wasn't attempting to evade anybody. And as far as the bond revocation, Your Honor, the bond revocation requires a finding that I pose a flight risk or a danger to the community, according to OCGA 17-6-12, Ayala versus State 262 Appellate 417-585, SE2D 681, that was from 2003. Bond revocation requires showing of risk, not merely allegation of violation. I may have appeared at the court. I have appeared at every court date in this case. I've been pro se across 6 simultaneous legal proceedings. I'm a father fighting for custody of his infant daughter. I have every reason to be present and no reason to flee. I went to the clerk's office because I was trying to preserve evidence I believe was not being able to get to you. That is not behavior of someone who is a flight risk or a danger. I asked the court to listen to the recording, as you already did, and determine what happened matches the description and the contempt notice before making a bond decision that would put me in jail from now until August. This court has been I respect this court. I have appeared every time. I've appeared every time I was required to appear. I'm not boisterous or anything while I'm waiting in court. I am quiet, I'm reserved, and I'm very respectful. I've filed motions because I believe I have constitutional rights that are being violated, and that's not to obstruct anything. On May 1st, I was attempting in good faith to preserve evidence of the body cam footage the state represented did not exist, but which did not exist, but which both arresting officers' own reports confirmed was logged and uploaded. I should have left a filed and written motion about the clerk's refusal rather than leaving the materials. But obviously I wouldn't have been able to do that because everything has to be e-filed. I understand that now, but good faith conduct, however imperfect, is not criminal contempt. Criminal contempt requires willfulness, a deliberate, specific intent to obstruct the court. That's OCGA 15-1-4, Tolbert State 290. Georgia Appellate 288 from 2008. The recordings show I was cooperative and calm. I was not willful. And because of this, I hope that you're able to find those things to be true.
All right, thank you. Ms. Sexton?
Thank you. We're here on a indirect contempt charge. We're here on a status review of the bond. And I think why we really have to understand we're here is that despite Christopher Stringer's words, despite the defendant's words, the absolute essence of this case is a lack of respect. The absolute essence is a lack of respect. There was a lack of respect when dealing with Mr. Charles's office. There was a lack of respect when dealing with Mr. Singleton's office. And with all due respect, there is a total lack of respect dealing with the state in this case. Even in his closing, he is arguing that I have footage that I never turned over to him. The state never had one single slice, piece, molecule of evidence that we have not turned over. If Mr. Stringer, if the defendant is going to act pro se, having dismissed 2 of his attorneys, he is going to have to deal with the fact that it is incumbent upon him to know this system. It is not fair to expect him to say, I did not understand this. I did not know this. I was not told this. He had an excellent public defender. He chose to dismiss that public defender. He had an absolute excellent local law firm, and he decided on the eve of this situation to fire them. We are not responsible for those decisions. When he made those decisions, it's incumbent upon him to know how he has to work around that situation. This court should not give any deference
to the fact that he is not an attorney. None whatsoever. He has chosen to walk away from two separate law firms. He has chosen to accuse the state of withholding evidence and has called it exculpatory evidence, which is the only reason that Baker would apply. And he stood in front of you and read AI pages and pages and pages. And you simply asked him, let me get this straight. Are you accusing the state of withholding evidence? And the answer was yes. The state has never withheld evidence. The state did not give him did not misrepresent the officer. And again, this is being stated. There is an incumbent lack of respect of this court that at every turn he questions. We have, quote, thrown blocks in his defense by not giving him, by misrepresenting who is out on FMLA. Never once did anybody ask me who that officer was. Instead, he was filing motions, and yet indeed is filing motions that continuance was not proper. His information has given the state and this court no benefit of the doubt. At every turn, this office has been accused of malfeasance. And it's about time that he is not excused for being pro se. It was his choice to walk away from that firm on the eve of that filing. And by the way, that filing, there was no hard deadline for that. There was a reference, let's put this in perspective. There was a hearing, and you said, I have no information that the court, I have no information that the state is withholding evidence. No information. If you have any information that the state's withholding evidence, we'll rehear it. There was no information the state was withholding evidence. And yet here we go again. The motions are filed and refiled and refiled. The state is busy. The court is busy. I'm tired of being accused of lying. The state is tired. The state is tired. At every corner, I have been accused. There is a transcript which states that the defendant knows that his attorney handed over that documentation, that hard drive to me. There's an insinuation that I had that hard drive, but I'm not letting you see it. That is never the case, Your Honor. And then on this day in question, on this particular day in question, this man walks in, and while it may not be illegal, it is really bad form to record the clerk's office. And by the way, we have no information and no recording about how Carly handled that before she went up and tried to find somebody to help her and talk to Patrick Shepard. Carly went above and beyond to try to figure out if she could help him. Above and beyond. She tried to find you, she tried to find the head clerk, she tried to find all these people. She ran up and she talked to Patrick. As we've established, she's not a judge, but she talked to a judge. She went above and beyond, and yet, at the end of the day, whether it was shoving, gently placing, maneuvering, whatever verb you want to use, that evidence left his hands and got sent through a window, which is a protective window that protects our clerks from the public, and things don't go through that window without the clerk reaching for it and accepting it. There is absolutely 100% evidence that has been presented in this court that he was aware that he could not file it, that he was told repeatedly he could not file it, and that he disrupted the process of that clerk's office to the point that all of the clerks sat and watched this. Carly's been a clerk for a long time. This has never happened to her before. She's under orders not to accept an e-filing. She's not under orders. As a matter of fact, she's under express orders not to give legal advice. She is not allowed to give legal advice. This is a pitfall of dismissing your attorney because your attorney will not go after the state for an FMLA situation, which was incorrect. If Mr. Stringer wants to represent himself, then he is held to the code of an attorney who knows the rules of the court, the ethics of the court, the processes of the court. And he violated those processes and he disrupted them. Therefore, the state asks that the court finds that Mr. Stringer is guilty of contempt, of indirect contempt. And in the alternative, the state is requesting that the bond status be reviewed and revoked.
All right, thank you. Okay.
Your Honor, I don't know.
Okay. We're done. I
That's what I was asking.
I gave you your hearing. It's my turn.
That's exactly what I was asking. Yes,
Yep.
sir.
Glad you asked it because we're gonna clear that up because I don't want you to interrupt me while I'm doing my part.
Yes, sir.
All right. The evidence as I've heard it is that Mr. Stringer personally appeared in the clerk's office. I believe it would have been the 1st of May, which is the day after his attorneys filed a motion to withdraw, to file, and he also electronically filed paperwork with the court clerk that he wanted to represent himself. I had not yet signed the order yet because those gears had not made it to me. And frankly, I think I was out of the office that day. And so when I got back, I have had to deal with this issue extensively. And I should not be dealing with this issue.
Yes, Your Honor.
I granted your speedy trial demand. I have put the state on alert that they will try this case in August or I will dismiss it in September. You got what you needed out of me. And in return, you said about me not allowing you to put it into evidence that day. That was not the time for that video to be placed into evidence. This is not the time to be placed into evidence. I'm just doing it because I'm tired of talking about it and you desperately want me to watch it. And so I'm going to let you put it in. But my point is that I have had to spend hours dealing with this issue.
Yes, Your Honor.
Which is utterly unacceptable. Because your audio, you think it helped you, it hurt you. I heard you very clearly on that audio say, well, I'm leaving it here. And then today you said that you had no other options. And you have chosen to represent yourself after letting and Ms. Sexton was correct about this. You had, frankly, the best public defender in the state of Georgia representing you in this courtroom. Harry Charles was the capital defender before he retired to come work for us as a hobby. He is a brilliant lawyer and knows exactly what he is doing and is a very effective attorney. So you had a brilliant public defender looking out for you. You fired him. You then brought a brilliant local defense attorney office in to represent you, which I made no secret from the bench. I was very pleased with because it meant that we didn't have to deal with you directly anymore because frankly, your personality is a very strong personality and it can come across as abrasive.
I apologize.
And so I'm just saying out loud that you had a wonderful buffer between you and the court doing this. And you let them go and decide to represent yourself. The only reason I bring that out is so that you hear me say that I'm hearing very clearly that you want it both ways. You want to both represent yourself and talk about how you don't understand how it works and you're confused and you don't know what to do. Well, the fact is that if you're going to represent yourself, I'm going to hold you to the same standard I would hold any lawyer that was sitting at that table. And I'm not going to put up with your shenanigans and nonsense and anything else anymore. You are going to operate at the level of professionalism, the level of respect, and you are going to listen to the directions that this team is giving you, and you will follow those directions.
Yes, Your Honor.
And none of those directions are going to keep you from advocating fully and loudly as best as you can in your defense.
Yes, Your Honor.
But the next time I hear so much of a peep about you causing any noise, I'm going to revoke your bond in full and we're going to be done.
Yes, Your Honor.
Am I being extraordinarily clear about the razor's edge you are standing on with me?
Yes, Your Honor.
Because I clearly heard Carly Evans tell you very clear instructions that I had no trouble understanding. And your response, and I wrote it down from your audio, was, well, I'm leaving it here. And you left it there, and I heard her calling after you while you were leaving. Mr. Stringer, Mr. Stringer. I heard her calling, and you ignored her. Now, you may say you didn't hear, but I don't care what you think. I'm telling you what I heard, and I'm telling you what my conclusion is.
Yes, Your Honor.
I'm telling you that your actions that day have taken up countless hours of my life dealing with this issue when we should all be getting ready for trial.
Yes, Your Honor.
Okay? So, is there enough for me to find beyond a reasonable doubt that you have committed the offense of indirect contempt by disrupting the clerk's office? That standard is beyond a reasonable doubt. I find that for that standard, the answer is no. I do find fully that by preponderance of the evidence, your actions have severely disrupted the operations of this court. I am so frustrated right now that you don't want me to make this decision from the bench. You want me to take a little time and calm down. Because if I make this decision right now, Cersei's going to put handcuffs on you and you're going to go to the jail till I calm down. So instead, we're going to do this. We are going to wrap up this hearing. You are going to quietly pack up your stuff, respectfully get your bag together, and quietly leave this courthouse.
Yes, Your Honor.
You are going to send that Google Drive link with these videos on it to myself. I've given you my email address. You've already got Ms. Sexton's Gmail address. And I will review those again before I make a decision. But you're going to get an order from me that is going to significantly change your bond conditions. Because I no longer have faith in you that you are going to interact with this team in a way that is respectful and professional and courteous and all of the things that you have every right to expect from us to you.
Yes, Your Honor.
And I don't think it's fair for me to ask my team to extend those to you when you have shown a very clear pattern of not extending those to us. So the answer to the question is no, I don't find that you have, I do not find you in indirect criminal contempt. So those 20 days are off the table. But I do find that you have absolutely disrupted the orderly operations of this court. And I do have the absolute right to modify your bond conditions, and I will be modifying your bond conditions. I may revoke your bond conditions, but I'm going to take a moment and breathe before I do that because you would want me to do that.
Yes, Your Honor.
Any questions before you go?
No, Your Honor.
Okay, you want to put anything else on the record before we part ways?
No, Your Honor.
Okay, anything else, Ms. Sexton? Okay. You need to get those videos to me by tomorrow at 5. It's Thursday after lunch. Hopefully you can get them to me today. And I expect to give you my decision pretty soon.
And I have your email. Is it okay if I ask Ms. Sexton for her email?
Yeah, y'all can do that off record.
Okay.
So anything else?
That's it, Your Honor.
Okay. All right, that's our last hearing. Issue the warrants, forfeit the cash bonds. Anything else? Okay. All right, we're adjourned. Get her email address, quietly, respectfully leave here. And if you want to apologize to Ms. Evans on the way out, you should.
Sure.